Court, all rise, please. Katie. All persons having anything to do before the Honorable, the Judge of the Appeals Court, now sitting at Boston within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is open. Please be seated.
Good morning, everyone, and welcome to the Appeals Court. Seems that there's some folks stuck in traffic, so we're doing things a little bit out of order this morning. So for those of you here early and ready to go, thank you very much. Just to introduce the panel, my name is Amy Blake. To my right is Justice Joseph Ditkoff. To my left is Justice Andrew D'Angelo. We will be your panel for the 6 cases that are scheduled for hearing this morning. Most of you that are here have been here before, but just to briefly go over the rules, each side is permitted 15 minutes of argument. If you are splitting your time, please let the timekeeper know that. We have read all of your materials, so you should get straight to your argument, and as you know, there is no rebuttal. So with that, I'm going to call Commonwealth versus DIRISU, I apologize if I mispronounced this, Clifford ALASA Jr., docket number 23P622. Counsel, good morning.
Good morning. Please the court, Adriana Condratizzi, for the defendant appellant, Mr. DIRISU ALASA. In this case, Mr. ALASA contends that he did not have a fair trial and he is entitled to a new fair trial, mainly because of the percipient witness police expert testimony of FBI Special Agent Broadus. And in my brief, I noted, synopsizing 7 reasons why the percipient witness expert testimony, which nobody really knew he was an undesignated expert. Even the judge was surprised when the Commonwealth subsequently called a different expert. So the first reason is that Special Agent Broadus's testimony as his expert testimony preceded his percipient witness testimony, which I think bolstered his percipient witness testimony. The second reason is that there was never an instruction on expert testimony prior to Special Agent Broadus's testimony.
Has the defense provided any summarization of what he would testify to regarding what you say is expert testimony in discovery?
No, he wasn't voir dired like as the other expert was.
I know he wasn't voir dired, but as far as expert disclosure and written discovery, was there any unfair surprise to defense counsel that he might testify to some of the common traits of this type of activity or anything like that?
I'm sorry, I can't answer that. But I think that everybody had contemplated that he was just going to be the percipient witness testifying that he was at the bottom door of the parking lot. The next reason is that when he testified to finding the defendant in his car was getting ready to smoke a big marijuana cigarette that was apparently the size of a cigar, I think you have to ask yourself, did the jury convict him based on this evidence, or did the jury convict him because he was going to be driving a car under the influence of marijuana, which, contrary to what my brother's brief contends, it is a crime, and I think it's very prejudicial. Nobody wants to have somebody on the road smoking marijuana or under the effects of marijuana. But the biggest reason, I think, is that in 2000, this court specifically addressed the identification of the in-court identification of a defendant by a precipient police officer who's also testifying as an expert in the Ortiz case. And in the Ortiz case, this court said it was an error, but it's really not reversible error. And we're aware that there was evidence in this case against the defendant, but it really wasn't evidence as good as in the Ortiz case. And I also note that the victim never testified, and the case was, even though there was an abundance of evidence, it was all pretty much circumstantially connecting the defendant to the crime. So I think that this kind of thing, where an undesignated police expert who's also a precipient witness comes in and testifies, I think that this court should follow Ortiz and recognize it as the error that it is and go ahead and reverse it.
If this was such a shock to everyone at trial, why didn't defense counsel object?
Well, that I can't answer. But quite honestly, objecting to something like that in the middle of testimony would just maybe have called the attention would have called the jury's attention to this witness's testimony and encouraged them to pay more attention. So it's always a thin line.
I don't understand. If you object, wouldn't that keep the evidence from coming in at all? You object, and the judge says sustained, and then it doesn't come in, and there's no attention drawn to it, right?
I think when the court voir dire Officer Detective McManus, the court laid down some very stringent rules about not using particular language, and she laid that down too as to the testimony of Officer Doyle. I don't think that the court had a chance to do that, and I think that a lot of because Special Agent Broad has talked about how his specialty was trafficking minors. This victim wasn't a minor. So I do think that the court would definitely have limited his evidence to what he saw when he arrested the defendant down at the bottom door. I really don't have anything else, and I think my brief is comprehensive on the issues, but I do think that he is entitled to a new trial. I think it's very damaging to a defendant to have an expert, precipient police witness identify the defendant on the stand as the perpetrator of the crime.
Let me just make sure that there are no...
Wait, identify him as the perpetrator of the crime? Where do you do that?
In Volume 4 on page 83. And ADA Ferreter just gave me that site, so I submitted a consolidated transcript, so I don't have the consolidated transcript page number.
I'm right. I didn't use the consolidated pages anyhow, so I did exactly that. I did it by volume, so.
I'm sorry, I didn't catch that.
I did it by volume too, so 843 is exactly what.
I do it by consolidated. I thought the court might prefer consolidated, so I always do it that way.
So it looks like he just identified him as the guy in the car.
The defendant?
Yeah.
Yes.
Didn't identify him as a trafficker, just identified him as a guy in a car he talked to, right?
Well, he identified him as the defendant in court. He identified, and I also note that Special Agent Broadus' testimony was 91 pages long. Detective McManus's, who was actually the expert, his testimony was actually 38 pages long. Officer Doucette's testimony was 17 pages long. Scott Marchand's testimony was 15 pages long. Peter Korber, who was actually, who pretended to be the purchaser or the client, his testimony was also short. So not only did Special Agent Broadus's presentation as a witness differ in that he was precipient, he was an expert or undesignated as expert, but it was also much, much longer. And he did do the in-court identification, which this court has specifically said is an error.
I don't see any additional questions, so we'll take the rest of your argument on your brief. Thank you very much.
Thank you.
Attorney Ferriter?
Good morning, Your Honors. Assistant District Attorney Timothy Ferret on behalf of the Commonwealth. Agent Brodus was certainly a very well-credentialed witness, but he was not an expert witness in this case. He testified to a professional background, the background of how the operation was set up that day, and then to his percipient witness of as in part of the surveillance team and finding the defendant in the parking lot. The only confusion was when he was asked to define the word date, but he wasn't asked to define the word date as an expert. He was just asked, when he was asked what he meant by the term date as part of his testimony. That was the confusion. It went to sidebar, and the ADA cleared up that she wasn't going to ask any further questions that called for any definitions of any terms related to sex trafficking.
On page 14 of your brief, you say that expert testimony is used to explain terminology and how businesses operate. Agent Broaddoor explained what platform meant and what proactive investigations meant, general setup, hotel stings, and what an analysis role is. Those are all definitions, aren't they?
No, so that's how the operation was set up. He's testified on page 61 to 62 that he was involved in this setup. He was the first witness, and he was laying out for the jury where everyone was positioned that day, and that's percipient testimony because he was part of the setup, and he confirmed that everything he testified to is how it's normally set up was in fact how everything was set up
So
that day.
how everything is normally set up. Isn't that describing how normal investigations like this are set up and everybody acted in conformity with that?
So I think it could have been cleaner if he just testified to how everything was set up that day. He kind of testified in generalities, but then he did confirm that, in fact, on December 11th, 2018, that everyone was in the positions that how he had described it. So I don't think this is testimony such as was in Lowry, where he did anything to explain how the different terminology used in the sex trafficking business. He was describing more of how operations are conducted, but not the sex trafficking
Page
business.
61 of the transcript. Question, in your training and experience, who is typically in charge of an internet advertising-based commercial sex business? Answer, most commonly it's a pimp that's in charge of those types. That's expert testimony.
I agree. I think some of that part kind of veered into it, but I don't think it was kind of the extensive expert testimony that McManus.
He's either an expert or he's not an expert. He testified to expert opinions, but now you're saying he's not an expert. So that's where I'm having trouble with your brief and your argument.
I think you could pick out one or two points that might have crossed the line, but he was not testifying really as an expert. I think you point out one part that might have crossed the line. It was unobjected to, but his testimony was as a percipient witness.
Want me to keep going on?
Sure.
Can you explain for us what role the pimp is with internet-based commercial sex businesses? Not in this case. He talks about it again in his experience. See, what I look to is every time an answer says, based on my experience or training, that's expert testimony. And he does that quite a few times.
I think the majority of that was in testifying about how the operation is set up, not in terms of how a business is run. And I think he was there to lay out for the jury how the operation was set up that day as the first witness and kind of set up the different players involved and how they would be conducting the operation.
Did the prosecutor who was questioning him know he was going to get into this? Because it certainly keeps talking and questioning about in your experience, in your training, general structure. Sounds like the prosecutor knew these types that he was, or she, I'm sorry, I don't know if the... She sort of knew that she was getting into expert testimony when she was talking about training and experience, and this is on page 62 of the transcript. How do we deal with that?
I just want to look at what you're referring to.
Again, it's line 4, page 62. In your experience, how many sex workers are involved? And then further down, the bottom industry term that you have come across. Describe the general structure of typical...
Sorry, what page are you looking at?
Page 62.
62, sorry.
Volume 4?
Volume 5, I think this is. Hold on.
Volume 5 or 4?
4. I'm having trouble because the number that's at the page on the transcript is...
I'm sorry, I'm on
Page?
Brodus's testimony 62 is talking about how they choose the hotel
Sorry,
location.
I'll come across it again.
562 is McManus.
I'm sorry, I had the wrong page. This was after the objections. Just move on. I'll come to it again. But
Okay. I think there's no objection in this case, and I would say I think you could point out maybe a couple places he crossed the line into an expert testimony. I think that was cumulative of what McManus testified to, and most of his testimony was about his percipient role that day, how everyone was set up, his professional background, and then his work on the surveillance team. In terms of the second argument about prior bad acts, I think they're both properly admitted. Giving a false name to police is classic consciousness of guilt evidence, and it showed that he was conscious that he wasn't just dropping someone off at the hotel, that he had knowledge of the illegal activity that was happening. And when the officers approached him, he was looking down and focusing on a cigar wrapper and marijuana in his lap. I think this showed that he was probably settling in to wait for the half an hour of the prearranged date. And additionally, with the overwhelming evidence in this case, there would have been no prejudice to the defendant. I particularly point to SRA 17 and 18, where you look at text messages 189 to 194, where we know...
Little slower. Could you get that to me again?
SRA 17 to 18, and the text messages are numbered, and I would look at 189 to 194. At that point, we know the phone that was used to arrange the date is with the defendant because the victim is in the hotel room, and he continues to send texts setting up the next date. Someone asked him, are you available for an alcohol? He responds, yes. Where are you at? How much time you want? So I think there's clearly overwhelming evidence in this case, and additionally with the other text messages involved.
I'm sorry, I have the right page.
Okay.
Page 55. So
Alright.
first,
Volume 4.
Volume 4. Can you describe for us what the general setup of one of your proactive investigations would be like? Not this one, but general. So is that one of the ones where you said it bled into it a little?
No, I think, again, this is a part where he could have testified, or probably should have testified, what happened that day particularly, but he did then come around on page 61 and confirm. He said, and can you confirm that the general stuff you described was in fact how it was set up on December 11th, 2018, and he said it followed the operational plan that he just described.
Isn't that what the case law warns against when a percipient witness combines what a expert does with what happened in that case, that's where that line gets blurred?
I mean, he's testifying really to his expertise in setting up an operation, which isn't really what we're concerned about in a sex trafficking expert case. That's really what McManus testified to. They're concerned about the terms used, how the business is set up, not how the operation, a hotel sting is set up. And I think that's where the expert testimony came in this case. Here he was testifying to how the operation was set up, and he did confirm the generalities I just testified to was in fact the plan that was used that day. It might have been cleaner just to say on December 11th we had this person, this person, this person in this position. He said we usually have all these things, and then we did in fact have all these things on that day. So I think it could have come in differently, and it wouldn't have sounded so expert-like, but he did confirm that everything he testified to was in fact what happened on December 11th. And if there's any further questions, I'd be happy to take them.
Let me check. Seeing none, we will take the rest of your argument on your brief. Thank you both very much. The case is now under advisement. I'm told that the next case, case 3, is ready. So, counsel, I will call the next case, which is Commonwealth versus Lawrence Trahan Jr., 23P247. Or maybe not. Mr. Sacchetti? Mr. Speedy, I don't have a defense attorney. You may be in the other courtroom. Attorney Lee, feel free to have a seat. Oh, there he is.
I apologize, Your Honor.
No worries. Good morning.
Good morning. May it please the Court, my name is Carl Suchecki. I represent Lawrence Trahan in this matter. Lawrence Trahan did not get a fair trial in this instance. I think a review of the record will show that the two things that he was convicted of, there was insufficient evidence. No rational trier of fact could find that Mr. Trahan anally raped this girl. There's two competing.
Take a moment.
There are two competing stories in this case. One was the Commonwealth's case, which is that Lawrence Trahan raped this girl when she was 8 years old. Keep in mind that the girl at trial is 13 years old. She has two parents. One parent lived with Lawrence Trahan in the projects. Lawrence Trahan was poor. Her father was not poor. And the complainant would split time with the mother and the father. And it was very clear throughout the testimony that the complainant and her brother preferred to be with the father. In this particular case, there's more consistent testimony in the fact that the sister of the father paid the complainant and her brother to give statements about Lawrence Trahan.
Counsel, let's assume we agree with everything you said. The jury heard that testimony, and they chose to credit the victim's testimony about being raped. How do we overlook that in this case?
Because there's no rational way to give credit to the testimony when I'll go down as far as the anal rape. When she gave a statement. The very first complaint came out was the first day the sister paid them for statements. And the first day that she paid them or enticed them, however, it was like movies or GameStop, whatever. But she said that if you give me statements, she was trying to entice her brother to talk, and the brother did not testify. But the sister liked her aunt. She was very empathetic to her brother who had had troubles and was difficulty in school and fought and stuff. But the complainant had no issues in school. But the aunt said she would pay them for statements. So she gave her statement. And the very first day that she said she'd pay, the complainant made a statement. But the anal rape statement, the vastly different statement made shortly after the alleged events, and then at trial when she's a teenage girl, are completely, hugely different.
Do you have any case that says that we can ignore the testimony of a victim and judge her allegations incredible based on?
I think based on the evidence, no rational trier of fact could have found this. And my strongest argument is the second argument. Maybe I'll start with that first. The oral penetration. On direct testimony, there was no testimony.
I thought that was acquitted. They acquitted him of oral rape.
No. If I'm in error, I'm in error, but that's not how it...
On count 3, charging the defendant with rape of a child aggravated by age to oral intercourse on a child, what say you, Madam Foreperson, is the defendant not guilty or guilty? Foreperson, not guilty.
My bad. But in terms of her touching, that before trial, just a month before trial, the complainant came in and gave statements that were new, and the new statements were, one was a vaginal penetration, and the second was the touching, and the touching that he was found guilty of. And neither, no, that might be wrong there too, but the fact is that this witness was not credible, and not credible in the sense, not just, this isn't small instances of a difference between. It's the anal rape, for example. When she first gives her statement, she says there were 3 times he tried to anally rape her on the same day. And she describes that he came up. At trial, she says there's only 1 instance of anal rape. She tries to say that it was on her butt, and then for further questions, she says it was in her butt. She says it was in her butt for 3 minutes. There's no indication that there was any lubrication used or anything and she said it was, quote unquote, uncomfortable. And it only felt weird because his hand was on her waist. There's so many instances where the complainant's story vastly changes, including that's just at the close of the Commonwealth's case. And when the defendant presents his case, we find out that she also did not testify. She didn't say that she had a touching. She didn't say anything about vaginal rape. And the anal rape was not the way she described. She says she was on her belly in one instance and on her back in the other instance. He was holding her hand in one instance and on her back, holding her legs in the other instance. The contradictions and the vast differences in testimony from her statements and the ones given at trial, there's no way a rational trier could have found that. And in regards to the judge knew that the complainant was susceptible to suggestion, and even at one point said that, regarding the oral count, was that she's going to adopt what he says, and it's true. She just seemed to be going with the wind, and Mr. TRAHAN did not get a fair trial in this instance, and we urge the court to find that. In addition, the closing argument, and it was only one statement, but the defendant's desire for a just verdict, the Commonwealth proclaiming that do you do the right thing, give a just verdict, which is not, it's pretty much telling you have a duty to convict. And it's our feeling that's completely unacceptable, and it's a substantial miscarriage of justice and severely prejudiced Mr. TRAHAN. So in regards to this case, Mr. TRAHAN was found guilty for essentially paid statements from the complainant, and because the case for the statements is just as equal as the case for the Commonwealth's case. In fact, there are less contradictions in the fact that the aunt paid for statements than there were that put holes in the Commonwealth's case.
I don't see any additional questions.
All right, well then, we'll rest on our brief.
I'll take the rest of your arguments on your brief. Thank you so much. Attorney Lee?
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. So the defendant's claiming insufficient evidence, but the entire basis for his claim is not the Lattimore standard, but is the credibility of the victim in this case. He points to inconsistencies, the lack of physical evidence to support her, the fact that there might be motive to lie because the aunt had given her money. That is a credibility argument. You can make that argument at trial and the jury can decide it, and it is the exclusive province of the jury and most respectfully not the appellate courts. And I cite to Brum, Holliday, and Duguay. The Supreme Judicial Court in Capaya said that it's okay for the Commonwealth's witnesses to have inconsistencies in their testimony. That's for the jury to hash out. That's what we have for cross-examination for. And in this court, in Gonzalez-Santos, said a very important point of law, and Gonzalez-Santos makes it clear, the authors of Gonzalez-Santos were surprised that they didn't have this formally stated before, that a rape victim's testimony by itself is enough. And that is a very clear statement that needed to be said earlier than Gonzalez-Santos, but this court can take that and not with a grain of salt, can take that as hard law, that when a person gets on the stand and testifies and the jury believes them, that evidence is sufficient, and that is the heart and soul of the Lattimore standard.
Just because it takes a while for something to show up in a case could be a reflection of how long it took someone to argue it rather than it being unsettled.
Well, I think we're seeing more arguments on that from the defense, and they certainly can make those arguments if they so choose. This case, my brother is making many claims about where the victim's testimony was inconsistent. There was an acquittal in this case, and that acquittal, I mean, we can't really read into what a jury does, but that acquittal references the testimony that the victim did not give in her direct testimony. The prosecutor erroneously believed she had testified to it and checked it off on his notes and thought she had testified to it.
You say direct testimony, you mean direct examination?
In her direct examination, yeah. The record shows she was testifying very quietly. At one point, someone said she was whispering. So I would suggest that's a reasonable inference why the prosecutor made the mistake he made. So on cross-examination, she's being asked, you didn't testify about this claim of an oral rape, and the prosecutor stood up in front of the jury, and should not have done that, said, yes, she did. And a very experienced trial judge brought them to sidebar and said, no, she didn't, what are you doing? and gave a very stern instruction. She did not testify to that, ignore what the prosecutor said. And then they moved on, and then she testified to it on redirect, and sure enough, that verdict comes back as a not guilty. And you can see where the jury got there, that she was being reminded of it. She did talk about it on cross-examination a little bit, like you didn't even testify to that. And then the prosecutor's statement, that was to be disregarded, and then the follow-up redirect comes back an acquittal, and the defendant's already had his remedy on that. So I would suggest under Commonwealth versus Avalos, when the victim testified that the penis went into her butt, she could feel it inside, that it was uncomfortable. She said that he was trying to do it for about 3 minutes. I would suggest that testimony is sufficient under Avalos. The Croft case about two equal but inconsistent propositions does not apply here. I cited to the Supreme Judicial Court's decision in Tavares, which expanded on Croft. And that case says you only use Croft when conjecture is required to determine whether there's guilt or not. There's no conjecture here if you believe the victim, and the jury believed the victim. There's no deterioration of the case either. The defendant testified and presented evidence and talked about his work schedule, but his work schedule would get him out early in the day, noontime or 2. Sometimes he traveled around on his work. All of that testimony would suggest that the defendant would get home in plenty of time to have access to the children alone, and he even testified that he sometimes would be home alone with the children. So there's no deterioration there.
Counsel, what were the specific acts of the indecent assault and battery that the jury could have found?
The indecent assault and battery, so there were prior bad acts as well. So the indecent assault and battery was that he touched her naked breast with his hands. That's at transcript May 2nd, 2022, pages 57 and 66 to 67. She was 8 or 9 years old.
And that was during a different episode than the anal rape, or was it the same?
I'm sorry, my memory is not clear on whether they are different dates or not. I believe she, because there's prior bad acts, right. So I don't want to say something that's not correct. But the prior bad acts in this case, for example, one of the prior bad acts she had disclosed on the eve of trial, and so she was cross-examined about her late disclosure on that. He was not charged for that. So, but that evidence under on the indecent A and B would also be sufficient. I cite Rosa. That's the one where where a neighbor put his thumb in a 14-year-old girl's mouth. But also we have the Levine case, which is a thigh touching. So I think that the evidence here is well within that as well. And I'll just move on quickly to the closing argument issue. The Commonwealth maintains there is absolutely nothing wrong with this closing argument. The problem area that my brother is raising is that the prosecutor said, I know you will reach a just verdict. Asking for a true and just verdict is completely proper under Commonwealth versus Cole and Commonwealth versus Savello, cited in my brief. The Assistant District Attorney here did not ask the jury for a guilty verdict. That is actually not something I recommend. I think you should be asking the jury for what kind of verdict you're looking for. And the problem that my brother raises comes when you equate a guilty verdict with justice. But that's not what's done here. If you look at the closing argument of the trial prosecutor, he didn't come close to that. He's asking them to consider the evidence. When considering all the evidence, looking at what the victim told you, how she told you about what happened, look within yourselves, think about these charges, think about all the elements of those charges and how she talked about the charges, and I know that you will reach a just verdict. You will consider all the evidence. You will not take this lightly because this is something you've sworn to do. I know that you will reach a just result. He doesn't even say, find him guilty. He doesn't say he is guilty. He doesn't equate a just result with guilty. He's saying, do exactly what jurors are supposed to do. You took an oath. You swore to take this to heart. Do that. And that's what jurors are supposed to do, and prosecutors are permitted to ask them to do that as long as they're not equating a guilty verdict with justice, and he did not do that here. So I would ask this court to find that there are no errors and to affirm the verdicts in this case.
I don't see additional questions, so we will take the rest of the argument on your brief. Counsel, thank you very much. The case is now under advisement. Mr. Spady, can I just check with you? Definitely not going in order of the list today because people are arriving at different times. So the current plan is we're going to hear the DCF case next. So if the lawyers want to get starting to set up on that, I know I have a Zoom lawyer on that case as well. I also understand that the first civil case is ready. We may take a break after the DCF case and then get that case set up. There is a criminal case that we are still waiting the arrival of the prosecutor. We have called that office. We do not know her status. And the last case on the list is still the last case on the list, and I don't think anyone's here yet on that case. So I'll keep you posted as people arrive. But that's, unfortunately, we are not going in the order that we planned, but we're flexible. So let me just make sure. Attorney Kornbluth, can you hear us?
Yes, can you hear me okay?
Yes, and what I'm told is I'm not going to have a timer for you, so when it is your turn, I will advise you of the time, if that's okay with you.
That's fine, thank you.
Okay, so, and as we get this case set up, let me just remind everybody that the case is impounded, so we're not going to use any names. I want to note something, though. There are 3 children. The clerk's office has designated the appellant child as child 2. I believe the department refers to that child in their brief as child 1. So for our purposes, we understand child 2, and I won't use that child's name, to be the appellant, okay? So I know that's a little bit confusing. And then just so we're clear on the time breakdown, so Attorney Kaiser is 9 minutes, Attorney Caffrey is 6 minutes, yes? Okay, and then on the other side, each of you is 5. That makes it easy. Okay, so I think we're ready on this case now, which is the Department of Children and Families versus Child 2 and another, docket number 23P1172. Attorney Kaiser, we're going to start with you.
Good morning, Your Honors. My name is Jean Kaiser, and I represent the appellant child 2. Child 2 request this court to reverse the judgment terminating her mother's rights. And I want to focus my portion of the argument on the second part of the termination of parental rights status, and that is that it must be in the child's best interest, and termination is not appropriate unless the child's welfare demands it. And I specifically want to focus on the deficiencies of the adoption plan in this case, because a crucial element of the best interest analysis is what alternative plan for the child's upbringing DCF has brought. Here, DCF failed in its duty to present a plan for child 2. It instead verbalized a hope, quote, that the child would be adopted by the same foster parents who at least 9 months earlier had asked DCF to remove the child from their home because they could not handle her behavior. The trial court similarly failed in its duty to make detailed and child-specific facts that are always required in these cases, but were especially important here because DCF did not submit a written adoption plan. But instead, what the court did is it made a single factual finding related to child 2 about the plan verbalized by DCF. And then, compounding the problem, it made a conclusion of law that the foster parents were, quote, ready, willing, and able to adopt child 2 when there was absolutely no evidence in the record to support that statement. As a result of the judgment, child 2 is a legal orphan. She resides in institutional care, and there's no evidence whatsoever that DCF has a plan to resolve her situation.
Counsel, this may be a fine point. The ready, willing, and able phrase, is that a finding of fact or a conclusion of law that you say is erroneous?
It looks like a finding of fact, but it is actually contained in the conclusions of law. But I think the important thing about it is that there was no testimony whatsoever that the foster parents were ready, willing, or able to adopt the child. Instead, what we heard from the DCF witness was that there was a hope, quote, that after assessments were completed, that the child could return to the foster home and be reunited with her 2 siblings there and be adopted. But there was no certainty whatsoever.
So are you looking for a remand for more evidence on this or for a change to the decree?
I think that because the trial court in number 1 finding that there was a sufficient adoption plan, and then in number 2 finding that termination of parental rights served the child's best interests, the judgment should be reversed and the whole case should be remanded with regard to the mother's ability, to whether or not the mother's parental rights should be terminated. Alternatively, it should at the very least be remanded for a further articulation of an adoption plan, because what we had here was definitely insufficient. But in terms of the best interests, what's happened here is that the judgment severs the child's contact with the mother permanently, the mother who cared for her and raised her for the first 10 years of life, and forecloses the possibility of reunification.
So there's a lot of sort of hindsight in that. What the judge heard was that the plan was for placement in this home, that the girls are getting along now, they've been having biweekly visits, would like to be together in the future, and that your client was very much improved at the home. With that evidence in front of the judge, why is it clear error to find that this plan's going to work?
On its face, Your Honor, that sounds like evidence. However, it's important to recognize that the evidence on this matter was hardly detailed. It consumes about 3 pages of the transcript. And I think a real problem with that evidence is that it is undermined by the additional evidence that was submitted by DCF, the documentary evidence. The DCF social worker testified that the child had only moved to the residential care in August. However, the DCF's permanency plan that it itself admitted into evidence shows that she was there in February of 22, months before the DCF worker acknowledged on the stand that she was there. And then in May of 22...
Where does it say that? I couldn't find that in what you cited.
I don't have the site right before me, but it is definitely included in my brief, the site to the record.
You cited Exhibits 252 to 262, but I didn't see it in there.
My apologies if my site is incorrect, but it is definitely the case that there is a February permanency plan that says that the child is already in the foster home. And then Exhibit 57, I believe it is, which is the foster care review in May of 22, also says that the child is in a residential treatment center and is not doing well, is being suspended from school, is fighting. And so suddenly...
I'm sorry, Exhibit 57, what was the other exhibit you said?
Excuse me?
You said Exhibit 57, which is the May foster care review. Did you say another exhibit?
Yes, there's a February 22 permanency review, and then there is a May 22 foster care review. And both of those...
I see it. Okay. I got you. I'm with you.
All right, great. So both of those documents reflect that the child was already in residential treatment. And it's not just that. The DCF social worker who testified at the hearing, she was at that May 22 foster care review. So why she didn't know in November 22 how long the child had been in care. So I think that kind of undermines this very rosy picture. But further than that, our cases really require that the adoption plan be detailed. And on page 50 of its brief, DCF favorably compares this adoption plan with adoption of DIRISU. Well, in that case, the plan was written. In this case, even though it's a complicated case, there is no written plan. In that case, the plan discussed the child's mental health needs in great detail. Here, there's just this rosy picture of, oh, everything's good now, and it'll be great for the child to be able to return to this home.
Your time's getting close to done. What do we do with this February 2023 report that was added to evidence, but added evidence after the findings have been made, with no request to change the findings? I don't understand what we do with that.
Well, I think what that does, Your Honors, is it gives you in the record evidence that DCF's so-called plan fell apart before the findings could even be completed in this case. It never really was a plan. It was illusory. It was wishful thinking. And there was no backup plan whatsoever here. A good adoption plan, especially when there's a troubled child, will provide alternatives if the original plan falls through, which it did immediately here. And
I don't know if this is exactly Judge Ditkoff's question, but procedurally, is that evidence that we can consider and the judge should have considered? When it was over, the trial was over, it's just that the findings hadn't been made.
Well, what happened was that there was an assented to motion to introduce that into evidence sort of post-trial, and so that it would be on the record at this point for the appeal that the adoption plan had fallen through. So the judge entered it into evidence as the child's Exhibit 1.
I do see your time is up. Let me check with the panel.
Thank you.
We're going to have to leave it at that, Attorney Kaiser. Thank you. Attorney Caffrey?
Thank you. Good morning, Your Honors. I'm Attorney Colin Caffrey, and I represent the appellant mother. I wrote about many things in my brief, but today I wanted to focus my argument on whether mother's rights should have been terminated regarding the appellant twin and speak only by implication regarding the other children. First, I believe I can answer one of Judge Ditkoff's questions. The February 29B is I have it listed as being in the Exhibit Appendix 2 on page 251. I don't know if that's the starting page, but I have cited from that portion of it. Firstly, the termination of mother's rights was not in the best interest of appellant twin, child 2. Both before and after trial, this appellant twin wanted to return home. As my sister has said, the disruption started in February of 2022 when the foster parents asked her to leave the foster home. In May of 2022, the appellant twin, child 2, was only wanted to return to her mother. She didn't want to return to her pre-adoptive placement. I believe that Exhibit 57 says at one point that foster care report that she is only focused on returning to her mother, not returning to the pre-adoptive placement. And then even after trial, she still hadn't returned home. This was a child who didn't want to be adopted, who didn't want to return to her foster care placement. If not her mother, she would have no one else.
Well, hold on. I mean, at trial, her lawyer said she did want to be adopted.
Well, Your Honor, I think at trial, the attorney said that the position of both twins had wavered at that point. At trial, before trial, she clearly didn't want to return home, and before trial, she clearly wanted to return to her mother, and at this point, she clearly wants to return to her mother. I don't know what happened at trial. I don't know what that position was, but it certainly seems like that position that she wanted.
It's the same question I basically had for your friend, which is, doesn't the evidence in front of the judge incorrectly tell the judge that the appellant child wants to be adopted, wants to be in this house, and that it's going to work?
No, I don't think it does, Your Honor. At best, the social worker's testimony at trial was equivocal. She says they were hoping that the appellant child 2 would return home. They were hoping. I mean, a hope isn't a plan. And they were hoping the appellant child would return home. They also state that child-specific assessments have to be done to determine whether or not this child, twin 2, could be returned to the home. They treat it like it was a fait accompli, and it clearly wasn't when you are waiting for child assessments and you have a child that, at least in the past, had wavered. And the court never considered this contrary evidence. They never dealt with the February permanency plan report. They never dealt with the foster care report from May. They never dealt with the fact that the child care assessments hadn't been done. They treated it as a fait accompli when I think on the evidence it was far from a fait accompli. It was far from a done deal. Now appellant twin wanted to return home. She wanted to live with her mother, and she had lived successfully with her mother both in Boston and in Pittsfield for the first 10 years of her life. Before removal, the social worker, the DCF social worker, I apologize, said she appeared healthy and happy living with her mother. When she was living with her mother, the appellant twin had no behavioral problems, and that contrasts with what happened after removal. She was fighting with her sister. She was suspended from school. She destroyed the room of her foster care placement. In fact, DCF was looking for a CFC foster care placement, not even a regular foster care placement. It was clearly not in the best interest to terminate the rights of mother. This was a child who may never be adopted. The DCF plan was clearly insufficient. She had a bond with her mother that had continued even after removal, such that she wanted to return to live with her mother. It was clearly not in her best interest to terminate her mother's rights. The appellant twin may never have anyone else, if not for her mother. And I see my time is almost up. If there's no further questions,
I don't see any, counsel. Thank you. We'll
Thank you.
take the rest of the argument on your brief.
Thank you, Your Honor.
I now believe we'll hear from the department. Attorney Gallup? Good morning.
Good morning. May it please the court, Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the judgment of the lower court terminating mother's parental rights because of her unaddressed substance abuse, specifically with cocaine and opiates, the failure to visit with the children for 6 months before the trial, and then prior to that there was inconsistent and unproductive visitation, that she refused to meet with or even work with the department to improve her parenting, and she didn't demonstrate any gains in her parenting the entire time the case was pending.
Just because your time's so short.
Sure.
I'm having trouble understanding why you jumped to a termination hearing or decision when the child assessments are still undergoing, still happening. They're still in the middle of the child assessments to determine what would happen with the child. I mean, now we know what's going to happen with the boy. I mean, but with the girls, I don't understand why you jumped there. Isn't that premature to figure out termination at that point or accept a plan?
I can't speak to the scheduling of the court. What I would say is that the critical inquiry is the unfitness of the parent. And while the statute itself,
Well,
chapter,
that's a critical determination, but we also have to determine whether termination is in the child's best interest, which it plainly is if there's a good adoptive home to go in. But without the child assessments, I don't know how you get there.
well, a fully developed plan, while preferable, is not an essential element, and that's the adoption of Paula. So the plan is itself a plan. It's developing. It's in flux in certain circumstances given a child's life and where they are at the time. Additionally, the juvenile court retains jurisdiction over implementing that permanency plan under Chapter 119, Section 29B. So why the matter was heard in November of 2022 when the child assessment was still pending, I can't answer that question, but I will say that on the information presented to the judge that there was a child assessment pending, that the plan was to return the appellant child to the home with her siblings. On that information, the judge found it to be sufficiently detailed and that it was in the child's best interest, weighed against the mother who was ordered to attend the trial and didn't even appear, even though she said she was on her way.
The judge's conclusion, I guess a conclusion of law, was that there was a plan ready, willing, and able. That doesn't seem to be accurate. So what do we do with that?
I would suggest that it's not necessarily an erroneous statement. If the foster parents themselves had represented that they would accept this child into the home, the fact that the assessment was still pending does not negate the fact that the family is open to having her move in.
Do you object to a remand on reconsideration for the adoption plan for child 2?
The department does object to that because the juvenile court retains the jurisdiction to monitor the implementation of the permanent plan. So to go back and rehear evidence on the entirety of the issue.
What if we just did it on the adoption plan? For example, the department could present new evidence about whether parents are ready, willing, and able to accept child 2, and maybe child 2's position might be different at this point. We don't know. But couldn't that be a remand for that purpose only?
Certainly, but it doesn't achieve any different outcome than the 29B hearing, which is still scheduled and still implemented. And the child, the children retain counsel in the trial court. They also have the ability, so there's an annual permanency hearing under Section 29B. They also could conceivably bring the matter more frequently before the court in terms of implementing the plan. Therefore, remanding the matter, restricting to the issue of implementing the plan is, to a certain extent redundant if you still have that other avenue through the permanency, Section 29B.
Let me just check, because I do see your time has expired. I think we're going to have to leave it there, Attorney Gallup.
All
Thank
right,
you.
Thank you.
On behalf of Child 3, Attorney Beal? You represent the youngest child, yes?
No, Your Honor. I
child.
represent the appellee's sister.
The twin. Okay, I apologize. Your child 1.
Very good, Your Honor. Thank you. May it please the Court, Eric Biel on behalf of Child 1. Child 1 requests that this Court affirm the order and decrees of the trial court freeing Child 1 for adoption. Child 1 was in a stable placement at the time of trial with Child 3, the little brother. There was a bump in the road late last year where Child 1 was moved to a residential facility for a few months. I can report to the court, although this is outside the record at this point, Child 1 has returned to that home that she was in at the time of trial. With respect to unfitness, there were action plans in place for the mother here before the birth of Child 3. The mother was dishonest with the department about the status of Child 3, that the pregnancy continued. Child 3 was born exposed to substances, and mother did not participate in services for the entirety of the case and did not show progress in her parenting during that time. Child 1 was not in good shape when DCF obtained custody. She was medically neglected. She was behind academically. She has special academic needs and has an IEP. And I find it a telling fact that Child 1 was not able to read at the age of 10 when she came into DCF's care. Since that time, she has improved academically. She has an IEP, and although this is also outside the record, now has an advocate, an educational advocate, to help oversee the IEP process.
Just to be clear, your client would like to be freed for adoption even if something new goes wrong with the current placement?
Yes, Your Honor. Child 1 is now reunited with her little brother, with whom she was very close, and there is, I think, a lot of evidence at trial to that sibling relationship. Child 1 had also sought an order, post-judgment order for sibling visitation, which the trial judge allowed, and that visitation, as I understand it, has been happening and would continue to happen. The issue is left open in terms of post-adoption contact. Child 1 moved to dismiss. She had appealed. She moved to dismiss that appeal with respect to sibling visitation without prejudice, just to leave that issue open, depending on what happens post-adoption. I don't have anything further if there are no questions.
I don't see any additional questions. Thank you very much, Attorney Beal.
Thank you.
Okay, Attorney Kernblau, we're going to hopefully go live with you on Zoom, and we're starting at 5 minutes. I'll let you know when we're at about 2 minutes, if that's okay?
That's fine, Your Honor. Thank
when
you.
you're ready.
Okay. May it please the court, on behalf of who you're referring to as Child 3, it's the youngest child. My name is Deborah Kornblue, and my client is now 3.5 years old. He has been in foster care since the day after he was born. So he went into foster care on May 10, 2021. He has never lived with mother. There was a goal change in this case. I'm going to try to get to the most salient points because I have such short time. There was a goal change in this case on December 2, 2021, from reunification with mother to adoption. And the mother complains that DCF did not give her additional time because her attorney, like right before the foster care review, handed, not mother, she didn't attend, the attorney handed the worker a letter from the attorney saying, please give my client more services. And that somehow shows they didn't consider her illnesses or make reasonable efforts. However, I just want to point out the obvious, which is even if you agree with that argument, with mother's argument that they didn't give her more time before they changed the goal, DCF is not the judge, and the mother still had 1 full year to become fit and take care of her children, because the trial wasn't until 1 year later. So that argument really fails because she still had plenty of time. Now, the argument at mother's brief, page 43, that the lower court failed to conduct a child-specific analysis only addresses the twins. It doesn't address my client. And regarding my client, the evidence showed that the lower court used its broad discretion in terminating mother's rights to my client, who has lived in the same pre-adoptive family, and that family attends to his many needs, and he's lived there his entire life. There was evidence unrefuted that a pre-adoptive licensing study called a PALS was completed at the time of trial. It assessed the foster parent's ability and background to care for children. That's in the testimony of Shauna Bine. And the findings of fact describe the physical layout of the pre-adoptive home, where my client slept, and the makeup of the pre-adoptive home.
You're at about 2 minutes, counsel.
Okay, thank you. Regarding another one of mother's arguments, I think that has not yet been addressed, it is not correct that mother successfully parented her 3 older children before she moved to the Berkshires, the 3 oldest being the twins and an older child not part of this case. DCF was continuously involved with the family because of missed medical appointments and the fact that mother admittedly left her older child with her mother again after mother moved to the Berkshires. The twins' school had difficulty reaching mother when the school tried to call. And most importantly, as it relates to my client, there was serious neglect of the twins, and that has prognostic value because she neglected one of the twins' heart conditions at just the ages of between 9 and 11, and the other child's ophthalmological issues, her eye. And with regard to my client, he has the most serious medical problems. He was born substance abused, and he had to be withdrawn from drugs, and he has ongoing respiratory issues. So the evidence was that she neglected her other children's medical issues, she neglected her own health issues, rendering her unavailable to parent the children, and that she would be woefully not capable of attending to my client's ongoing medical issues, which the evidence showed his pre-adoptive family amply addresses at all times. So in conclusion...
You are at time, so if you could just wrap up.
Sure. The overwhelming evidence of unfitness was clear and convincing, and my client is asking that you affirm the termination of parental rights decree as to him and approve the lower court's decision to choose the adoption plan by my client's pre-adoptive family.
Thank you very much. The case is now under advisement. Mr. Spady, do we have any updates?
Yes, we are ready.
All of our cases are now ready? Yes. Okay. So I think if it's okay with the panel, we'll hear the criminal case? Okay. We're going to hear the remaining criminal case. We will then take the morning recess, and then we will begin with the first civil case. So we will now call Commonwealth versus HEROLIDO Candelario. Docket number 23P507. Attorney Mello? We able to shut the television off, Mr. Carter? That would be great.
At least the screen.
And before we begin the argument, just a reminder that the case is partially impounded, so we will not be using victims' names. I think we are ready to go. Mr. Benyon, good morning.
To the presiding justice, and may it please the court, let's talk about severance and joinder. This is pretty straightforward. It's the co-defendant, the brother of my client, who is alleged to have abused his daughter, MC, is how she's referred to. This was discussed in the materials. I quote the discussion in my brief, where defense counsel objects to the joinder based on the fact that my client, the appellant, has nothing to do with MC or the abuse. The trial judge said, well, I can give a curative instruction, and defense counsel didn't like that idea. I'm not really sure I like it either. I think that the principles of joinder and severability show that they just shouldn't have been joined. But nonetheless, they weren't. They went forward. Now, in my recitation of the facts, I do a nice job of pulling out this case. When you read the transcripts, if you haven't read them already, you'll see that the way the prosecutor approaches this is it's kind of a fluid, with each of the girls, a fluid recitation of abuse, both allegations against my client and the co-defendant, and that's where the problem lies.
Counsel, can I just make sure I have read the transcripts? There's no connection between your client and the brother as far as any evidence that they discussed what was going on with each of the victims, like almost like a conspiracy. There's nothing like that in the evidence, is there?
No, there's not. It's the allegations are that each of the defendant and co-defendant committed these separate, and so there's nothing in the evidence linking them. Again, that's
We had a Gilberto only trial.
Say that again.
We had a trial just of Gilberto.
Yes.
Do you think the MC charges would be properly tried with the other 4 victims?
Against
If
the
we were
co-defendants?
just doing a Gilberto, will be trial, I understand how different the one the judge excluded, but let's, the other 5 victims.
Against the co-defendant, yes.
Okay.
Absolutely. It's, the allegation is from MC against her father. That's the point. And also, you can look at it as it's more salacious, it's more incendiary, the idea of incest, especially where it's not drawn out to the jury that, because no instruction was given, even though the judge said, I can give an instruction, this is how I could give it, the judge never chose to do it. Defense counsel objected. He objected again before the evidence came in, but the judge is the one who chose not to do it. Now, this is important because there's nothing except the testimony of the complainants. I mean, that is the sole evidence against this defendant. And so when we have a jury, we have that black box where what goes in affects what comes out. And where we're relying so heavily on the credibility of the young girls, it is important for due process principles and for standards of evidence to remain high that if you are going to bring in MC's testimony against my client, you either you either sever or you give a curative instruction, which is the judge chose not to do. Now, I understand the defense counsel voiced his reasons why he didn't think that the instruction was good, but once the judge made the decision to join, then such an instruction would be necessary, at least according to principles of due process and fairness, because, again, we don't want the jury to impute my client's actions against, or the allegations against the other girls against MC, what the co-defendant did to his daughter. And again, I bring up the way the transcript kind of runs through it because it can be confusing. The allegations are so similar between what the co-defendant and defendant were alleged to have done, that it raises real problems here. And there's a reason why such a curative instruction should have been given. If you think that trial counsel had to object and say we need a curative instruction, then defense counsel is to blame. But I look at the case law and I see it's the judge. The judge joined them. It's the judge who said I can give an curative instruction, but the judge who chose not to do so.
Can we look at the objection to giving the curative instruction as a strategic choice?
No, you can't, because he's arguing that he doesn't say that, you know, I don't want to call the attention to the jury. He just says it's not, he just makes the overarching argument that, hey, the allegations against MC have nothing to do with my client. It is prejudicial. It has, I mean, principles of joinder should dictate that it doesn't come in. That was what the argument was. It was on the joinder severance issue.
Well,
I'm sorry. Aren't you arguing two separate things there? We might agree with you that joinder was not proper for legal reasons. But the argument that the instruction should have been given, hasn't counsel to a degree waived that by saying, I object to your instruction, I don't think you should give one? Or I don't like...
No, not that you shouldn't give it. That really wasn't discussed. But again, I look to, for example, Kirby versus Morales. It's within the judge's broad discretion to decide whether to even give the curative instruction or not. It's the judge who decides. Defense counsel's job is to raise it, which he did.
So maybe I'm confused. You seem to suggest you understood why defense counsel didn't want the instruction. Maybe I misunderstood.
I don't know. All I can say is what's in the transcript, and that is that they're talking about joinder and severability. He says, no, it's not going to cure the prejudice because it comes in, what the co-defendant did to MC. However, once the judge decides to join them, and because of all the other factors that I just talked about, how the evidence was presented, then a curative instruction would have been certainly better according to principles of due process.
Are you still pressing your ineffectiveness claim?
I'm sorry, say that again.
Are you still pressing your ineffectiveness claim?
It's there mainly to point out that, I mean, I argue that it's the judge's call. You might disagree. You might say, no, the judge has his broad discretion to do what he wants. Well, then somebody has to be held responsible for this, and I'll lay it at the feet of defense counsel. But no, my argument really is a thrust against the trial judge.
So shouldn't defense counsel have said something to the effect of, I object to joinder. He did that before trial, maybe should have done it during again, which I think he did. But if you're not going to agree with my joinder argument, you should give a limiting instruction, Judge.
Justice D'Angelo, we don't live in a perfect world, and...
But I'm trying to figure out why that's not waiver. I know it's not perfect, but it seems to me, again, just on the issue of the instruction, that there may have been a waiver when the counsel says, I object to that instruction.
No, I don't object to the instruction is not what he said. He said, I don't think it's going to cure the issue. And that was, again, in discussion of joinder. Once the defense raised the objection, then it's up to the judge to give the instruction. Would we like to talk about witness intimidation? Or
It's your time.
okay. Then why don't we move there? So this is just a pure statutory construction issue, which I like. The statute, I think, is plain and clear on its face and the way it's written. There's no ambiguity about it. There must be a criminal proceeding of some sort to commence before we are talking about whether the issues of money or bribery or threats are criminal or with the specific intent to impede a criminal investigation. Here, the evidence is quite plain, and it clearly shows that there was no criminal investigation going on whatsoever. Those indictments against two of the girls should have been dismissed on the motion for required finding. If you can't apply the statute in this way, it really is disturbing because it turns the court into almost a quasi-legislative body in the sense that you're picking and choosing how to interpret the statute, which I do not like. You're sworn to uphold the text. The text is clear.
Why aren't they potential witnesses?
They are potential witnesses, but they still have to be potential witnesses within a criminal proceeding that has commenced. Isn't everybody born a potential witness sometime in their life? Obviously, I mean, we need to have some principles of guidance for this. I feel that this has been applied a little bit too broadly in the past. I understand there's case law out there, but I don't want you to look at the case law. I just want you to go and read the text in the addendum of my brief, decide whether it's clear or not, and apply the text. These girls were not. Now, that could be a criminal, I mean, the government can indict on bribery or threat, criminal threat, but come on.
Well, but so it says, potential witness at any stage of a criminal investigation. These people, do they have the potential of being witnesses at any stage of a criminal investigation? I think the answer is yes, right?
No, there's no investigation. There's nothing.
No, but there's a potential.
Again,
the question is, are they potentially witnesses at a stage of a criminal
everybody's a
investigation?
potential witness. That's my point. It's
everyone who
so
commits a
broadly.
crime, everyone that's a victim of a crime might be, sure.
But again, when we're talking about whether it's a difference between, and thanks for engaging with me on this, but whether it's, when we're talking about whether it's criminal bribery or criminal threat versus an intent to affect a criminal proceeding has to at least commence, and that is one of the elements. Here, nothing commenced. It was just either a threat or a bribe.
So after a defendant allegedly commits a criminal act against somebody and says to that person, if you go to the police, I'm going to kill you. That's not intimidation.
Could be a threat. Could be.
It's not intimidation of a witness. That's a possible witness to a criminal investigation because the defendant knows what he or she did, right?
I see that. That's fine. But again, one of the elements is that a criminal proceeding has to commence. Again, please read the statute, interpret it reasonably. With that, thank you very much.
Thank you. Attorney Mello.
Good morning. May it please the court, Emily Mello on behalf of the Commonwealth. The Commonwealth would ask that you uphold the defendant's convictions. In this case, the two issues before you are the issue of severance and the issue of sufficiency of the evidence on intimidation of the witness. Here, there were 26 indictments for including 4 victims against the defendant. Against the co-defendant, I believe there were initially 17 indictments, including the same 4 victims. Thereafter, 2 additional victims disclosed, and so that was a separate indictment. Though that was 8 counts, and the first 3 involved MC, the co-defendant's biological daughter. Indictments 4 through 8 involved E.T., who I believe was a sister-in-law. The Commonwealth moved to join both of the co-defendants' cases. I think that the allegations that MC made were properly joined with the co-defendant's case. They happened in the same house during the same time period.
Sure, but like I was suggesting to your brother, I get why with Gilberto you're going to have all 5 victims in one trial. But then when we add Geraldo, do we have to revisit that?
I think we do, and I was just laying out why the joinder happened in the first place, because Geraldo is really moving to sever his case from the allegations that MC made. He is not moving to sever any of the allegations made by the 4 other victims. So when we get to severance, the question is...
But wait a second, the Commonwealth moved to join them.
That's why I was explaining that. No, not exactly. It's a little bit confusing procedurally. The Commonwealth moved to join both of the co-defendants' cases, which were 501 and 659.
Stop right there, I got that. Okay, join defendant and brother. I get that. So,
No, not defendant and brother. Co-defendant and himself. The Commonwealth moved to join, I see your looks of confusion, and it is a little confusing. The Commonwealth, there are 3 separate docket numbers here. 500 is against the defendant here, Geraldo. That includes 4 victims, all sisters. They are his nieces. 501 against the co-defendant, Gilberto, includes the same 4 victims, also his nieces. Those cases were already together. They moved together throughout the court. Then MC and ET come forward. The Commonwealth indicts allegations of MC and ET against the co-defendant, Gilberto. Then the Commonwealth moves to join, that's 659, just for purposes of, the Commonwealth moves to join 501 and 659, both of the Gilberto's cases together, which would result in 659 also being tried with the defendant before you, case 500. He moves to sever his case from 659 only. So he moves to sever only the allegations against MC. It's all sort of done in one ruling, which makes it a little confusing, but procedurally, really, there is a joinder, and although I think, styles his motion as in opposition to the joinder, he's really moving to sever in the event that there is a joinder, if that makes sense. So what this court needs to look at is whether the case 659, only the allegations including MC, not ET, that's not in play, whether those allegations should have been severed from Geraldo's case. And in order to look at that, the standard is, it's within the judge's discretion, and it should be ordered when the prejudice resulting from a joint trial is so compelling that it prevents the defendant from obtaining a fair trial, or 2, the defenses are antagonistic to the point of being mutually exclusive. Neither of those are present here.
Can we look to whether there's any prejudice from the fact that joinder should never have, that the indictment should never have been together to begin with?
I don't think so, because Geraldo is not really a party to that joinder.
Well, the Commonwealth chooses to indict brother and defendant at the same time.
So say that I'm taking that at face value.
Is that accurate? In
Yes.
this case, so by the fact that you did it together, you then don't have to go through the joinder analysis because you indicted them together.
And so the move would be to ask to sever. But he doesn't ask to sever what is already joined. He only asks to sever MC. He does not move to sever his case entirely from his brother's. And even if he had, I don't think that would have been allowed either.
Well, let's talk about that, because that's what I think is the important part. Joinder is only proper for 3 reasons that I can see. Is the criminal conduct or episode, it's 1, the same criminal conduct or episode. 2, it arises out of the same course of criminal conduct. Or 3, the series of criminal episodes are so connected as to be part of a single scheme. None of those apply to brother
They
and...
all apply. Raping your 4 nieces who are all the same age in the same apartment during the same time, and then additionally raping your biological daughter who is the same age,
why the
and that is
brothers?
not the same.
Why are the brothers
The
connected in that
brothers,
way?
he is, okay, so he's not moving to sever any of the allegations that have victims in common. He's only moving to sever MC. So the only question before this court is, was MC's testimony prejudicial against the defendant? And the answer is no, because she didn't even make any allegations against the defendant.
Counselor, I think that my colleague was asking, I understand that was not what he was moving for, but were the two brothers ever properly joined? And that may not be before us, but it is interesting.
I would say, first of all, as you just pointed out, that is not before you. And yes, what you are saying is that if they were not joined together, you have to look at the judicial economy here. You want to put 4 young girls in front of a jury to talk about how they were raped over a period of years by their uncle in a certain apartment, and then you want to try that case again with the same 4 victims, the same 4 young girls who were all
Counselor,
raped?
I sure don't, but does Rule 9...
Neither do I.
Does Rule 9 allow a judge to join counts just because of overwhelming judicial efficiency interests?
Unless there is prejudice, and there is none in this case. Sorry, I almost said her name. MC made no allegations whatsoever against Geraldo. There was no need for any type of curative instruction. There was no reason for the jury to consider those allegations against Geraldo. There was absolutely no prejudice. In addition, their defenses were not mutually antagonistic. They were not blaming each other. They were both saying that apparently all of these children were mistaken or made up the fact that they were repeatedly raped over a number of years.
In the same house, separate times, with 2 people that really didn't have any evidentiary connection, correct?
So what is the prejudice?
Well, I'm going back to whether they should ever have been indicted together. Other than the fact
that is not before the court.
Well, pretend it is, because I think the prejudice flows from that. The fact that they were in the same house seems to be the linchpin to your argument as to why they should have been indicted together.
And it was the same victims.
But separate
with the same allegations.
What do you mean by the same allegations? They're the same count. They're the same rape and rape, indecent A and B. But they weren't connected in any way. There's no evidence that the defendants talked about it together. There's no evidence that they planned it together.
Does there need to be?
Well, I'm asking you that.
The answer is no. There is absolutely no prejudice here. Not only is that issue not before the court, the only issue before the court is whether the allegations against MC should have been severed. She made no allegations against Geraldo whatsoever. The only time she mentioned Geraldo in her testimony was to corroborate the fact that he was living in that apartment and that her cousins were there at the same time. That would have been admissible regardless. There was absolutely no prejudice because neither victim, every single victim got up there and talked specifically, and the prosecutor was very, very clear about the way that she did this, talked first about the allegations with respect to one defendant and then with respect to the other. There was no crossover, and if there is no crossover, then there's no prejudice. What you are saying is that the jury would have been more likely to convict the defendant of horrifically raping his 4 nieces by the fact that also his brother did that. Who cares?
Respectfully, Counselor, we're not saying anything. We're asking you questions.
Are there any other questions on that issue? If not, I will move to the second issue. The second issue is the witness intimidation. I think that Fragata specifically interprets the statute and says that any potential witness in a criminal investigation, and the criminal investigation does not yet have to have begun. And if there are no other questions, I will rest on my brief.
I don't see any. Thank you very much. The case is now under advisement. We are going to take a brief morning recess. When we return, we will hear the Sabatini case. Mr. Courthouse, do you happen to know, I know that the press had gone downstairs to get permission from the Public Information Office. Has that occurred? to be present in the courtroom for the next hearing? Okay.
Court, all rise. Court stands at brief recess. Court is open. Please be seated.
Okay, I know that not everybody was here this morning, so just a couple of brief announcements. As all of you know, each side is permitted 15 minutes of argument, and there is no rebuttal. With that said, in the case that we're about to call, there had been a request for additional time, and we had denied that request. With that said, our timekeeper has been instructed if we go over because of the questions from the bench, we will keep track of that time, and I will ensure that all parties are permitted the equal excess time if in fact that occurs. I promise you that. I also wanted to mention that we did have an inquiry this morning from the press. I'm not clear that they have come back to the courtroom, but with that said, just for the record, this is an open courtroom. We are being live streamed on the internet, and this proceeding is available to watch at any time, as are all of our proceedings on our website. So with that said, we will get underway with our next case, which is David Sabatini versus KRISTIN, KNOUSE, and another. I'm sorry if I've mispronounced those. 23P0706. I understand the appellants will be splitting their time. Attorney Hodge, are you going first? Wonderful.
Good morning, Your Honors. May it please the Court, my name is Kay Hodge, and with my partner, John Simon, we represent the Whitehead Institute for Biomedical Research and its director, Dr. Ruth Lehman. I'm going to be referring to them both as Whitehead as I go along in my argument. But in addition, I want to make sure that since I am limited in time, and there are lots of issues that we have been asked to address, both with regard to the anti-SLAPP and also with regard to the 12b-6, I just wanted to say that we will rely on our brief, and I will attempt to just summarize and hit some of the high points as obviously I see it and as you ask me. Basically, Chapter 231, Section 59H, which is the anti-SLAPP statute, has a very broad definition of petitioning. In the Supreme Judicial Court's recent review of the area under this statute in Bristol Asphalt and Columbia Plaza, it essentially affirmed or reaffirmed the very broad definition of petitioning. It did, however, suggest that there were limits, and some of the issues that it addressed were, number one, you have the right to de novo review. Second of all, to review the decision of the trial court de novo. Second of all, that you should, that the trial court was not allowed to parse any longer the claims, and that's actually a pro-plaintiff position because, it would allow some of the claim to proceed even though it had been asserted as a single claim. And then the additional issue is that you can no longer have the ancillary path, the additional path, augmented pathway to attack the petitioning activity of the move-on. What you have here is a course of conduct. Whitehead was engaged.
Well, so you've already lost me, because one thing I know a petitioning activity has to be is written or oral statements. Every definition of petitioning activity is a written or oral statement to various things for various reasons.
Yes.
But there's no course of conduct. It's got to be statements.
Okay. Your Honor, I will say there are statements. There are applications to and from the National Institutes of Health requesting funding. Those
I get that, but you seem to be suggesting that you've got a SLAPP case against the breach of contract and against the claims of sex discrimination against Whitehead, and I don't follow how that could possibly be petitioning activity.
Your Honor, well, I'm not sure. My view is, if you read the allegations that are made against Whitehead with regard to either the discrimination or the contract claims, they all relate to the investigation. They relate to a written document which Whitehead has spawned, if you will, or the Whitehead investigation, which is a written document. And in that document, conclusions were drawn, which have in fact been reported in the statement of August 20 by Dr. Lehman to the community at large, and also repeatedly in a variety of other different iterations. Now, I will point out to you, Your Honor, that I believe that if all of these things are individually or collectively, what I would argue is a course of conduct of petitioning. In order to keep the funds, you have to do certain things. Now, I would point this court to, it is an unpublished 128 decision, but the first decision of this court interpreting Bristol asphalt was the case of Hanamura. And in that particular case, it involved the situation of a child was brought to the hospital. The doctor recorded what she saw in a written statement and recorded it. It subsequently became a report to the government. That was done before there was not an ongoing investigation. There was no charges at the time, but nevertheless, and that was considered to be petitioning sufficient that it moved the case to the plaintiff to show that it was devoid of any facts or law to support it. We would suggest that that is your situation here. What you have is all of this back and forth, and they are written statements that are being made to NIH, which include written statements that suggest that we will abide by, if you will, their expectations was to provide a research environment that is safe, harassment-free, and we would investigate in the event that there was anything that suggested that the environment and culture was not satisfactory. And indeed, that was the circumstance. We learned in March of 2021 that there were some complaints in a DEI survey. Those complaints resulted in the investigation that is at bottom, a written statement that is at issue here.
So if no funding was involved in this case, the investigation would not be petitioning activity. Is that your position?
No, our position is we were asking, it's no different than the situation in Office 1 where you were seeking to have a lease for the building. I guess it's just you were looking to get, to have the lease space. I guess, Your Honor, I think that, the funding is in fact a part of all of this. You know that Dr. Sabatini had 6 grants, and those were at issue in this case. And I would direct this court's attention particularly to the September 21 letter written by Mark Barnes on behalf of Whitehead, Attorney Mark Barnes, with regard to the response to NIH of a variety of issues. Among those were the fact that we had done the investigation, what the conclusions were, what we sought from NIH, and it also related back to the fact that policies and procedures had been put in place that NIH required that we have.
Does it matter to you how the counts get dismissed?
I'm sorry.
Does it matter to you how the counts get dismissed?
How the...
Does it matter to you whether it's a 12B6 or a SLAP for dismissal of any particular count? If we decide a count was properly dismissed by 12B6, do we need to go on to SLAP, or are we done as far as your client's concerned?
I think it's hard to say. It depends on how it gets, what exactly is the issue. We do have overlapping claims, and many of the anti-SLAP cases do that. And many times they will decide both a 12B6 at the same time that they decide the anti-SLAP. I think that in any event, we believe that there should not be any claims against Whitehead. And we believe it is because of what its constant and regular petitioning activity. But if your honors do not feel that, then you can obviously go to look at the, go to the 12B6 issue, because that was based on the complaint and the documents included within the complaint. Let me just be clear. It is our view that the trial judge on the anti-SLAP issue was wrong, was right and wrong. They were right because there was a direct exchange between Whitehead and NIH about this situation, but the content of what Attorney Barnes reported to NIH is the investigation and its findings. That is the reason, and all of that is, that's why I use the term course of conduct perhaps, but it is a volume of written and oral statements that are all combined together to essentially amount to petitioning.
One thing that's confusing me is, what happened to your fee request, your anti-SLAPP fee request?
Nothing. It's still pending.
Do you think that affects whether this is properly before us yet? Do you think that affects whether that's properly before us yet?
sorry,
I know
I'm sorry.
I know
I
a
was
SLAPP
having
motion is immediately appealable, but is it appealable before the fees are set?
You know, Your Honor, I hadn't thought about that. I'm not sure. I hadn't thought about that. I think it is clearly appealable before the fees are set in light of the Fabre and the other cases that have held that not only do you have a right of interlocutory appeal, but that the appeal includes fees. And so it would seem to me that it would make sense until you know what the end result is, that it would make no sense to actually have a hearing in order to try to ascertain that. Let me just say to Your Honor that we also have made a case about the stay of discovery during an anti-SLAPP case. We also suggest that we are not abandoning the argument made in our brief about the fact that the contract claim has in fact been waived, and do not believe the fact that this court allowed a 12b-6 to be essentially appealed on an interlocutory basis on the grounds that judicial economy is served, to now pick and choose the parts of the 12b-6 decision that you are really actually appealing. And with that, I see that my time
Check
is...
with the panel. It looks like we're all set right now. Thank you, Attorney Hodge.
Thank you.
Attorney Zucker?
Good afternoon, Justice Ditkoff, Justice Blake, congratulations, and Justice D'Angelo. I'm Ellen Zucker from Burns and Levinson, and I'm here with Nancy Gertner representing KRISTIN KNOUSE. I want to situate our discussion today for a moment. KRISTIN KNOUSE was, on the record, without dispute, a registered graduate student at MIT. When David Sabatini invited her to Washington and had sex with her, he has admitted this much. What is also without dispute is that at that time, he had been on her thesis committee, he had written her letters of reference for the fellowship she was about to begin at the Whitehead Institute, and he had been tapped to be director of that fellows program. He was a member, not in a training position at Whitehead, and indeed an executive of the Institute as one of its associate directors. That is in the record, that is without dispute. It is also without dispute that he continued what he called casual sexual encounters with Dr. Knous as she was in a training position as a Whitehead Fellow at an institute where he was an executive. It is not in dispute in this case that various policies at MIT, Whitehead, and indeed NIH were violated by his undisclosed sexual relationship that he maintained while not relinquishing his, to use the language of MIT, career influencing role over her. None of that is in dispute in this case. What happened here is that we have an appeal before you on the anti-SLAPP statute, as well as our appeal from the dismissal of a claim under 214(1)(c). We also have before you Dr. Sabatini's appeal of the court's dismissal of his retaliation claim, late filed and without a predicate basis of notice, against Knous. Now, Dr. Sabatini's counsel did not identify this among the issues presented in his appeal, so that argument has been waived, but we will rest on the papers on that because that fails both in terms of timeliness and notice. Now, let me focus for a moment on what the policies are and where we were. Dr. Knous, it is undisputed, at some point in 2019 and 2020, began making reports about what had occurred to her. that Dr. Sabatini would have wished undisclosed. She began thinking of coming forward and saying something. She spoke to MIT faculty, themselves mandated reporters. She spoke to colleagues. And then she made a report. Her report was in the language...
So you said MIT's mandated reporters. Are you suggesting those faculty members were committing crimes by not reporting it?
Under Title IX, MIT faculty had a duty to report whether they did or not.
Oh, you don't mean, I'm sorry, I thought you were talking about the other report.
My apologies.
Okay, sorry, I was confused.
She then participated after a survey in an investigation that was not only warranted, it was required, both as a matter of NIH funding and under the architecture of our anti-discrimination laws. There were concerns, they were earnest concerns under the state's MCAD guidelines provided in your papers, failure to investigate itself as a basis for liability, also look at Gulakian in that regard. Finally, and also under Farragher and Allerth, under federal law, which also applied here, a failure to put your employer on notice means you can't even bring a claim. She participated after putting MIT, HHMI, the funder of Dr. Sabatini, Whitehead, and Dr. Sabatini himself on notice of her concerns about potential claims. Tolling agreement was reached. She participated by providing information to Whitehead. And in Dr. Sabatini's brief, he concedes that Whitehead is, in a different context to be sure, a mandated reporter. Concerns come to their attention, they investigate, it goes to the government. So the question now...
Counsel, I'm aware of the facts, and you're doing a great job listing them. What turned it into petitioning?
So the petitioning activity here is the conduct preliminary to, involved in her internal reports to Whitehead, who are described at page 59 of my brother's brief as mandated reporters to the NIH. It is also petitioning because that conduct is preliminary to exercising your rights under our state and federal anti-discrimination laws. I'm sorry.
Mandated reporter, the affidavit of Martin Mullins says he had to report Dr. Sabatini's departure, but I didn't see anything that said they had to report the actual sexual harassment allegations to NIH. And I don't think they actually, did they send the report to them?
So if they find concerns meritorious, and they did on a number of bases, the sexualized work environment, the failure to be candid with the investigation, the interference with the investigation, the threats of retaliation, and indeed his leveraging his power, to use the language of the HAS report, leveraging his status and power to engage in a sexual relationship with Dr. KNOUSE, who was indisputably a subordinate in this setting. So to answer, to go back to your question.
Well, so you said if they found that, and I expected you to say something after that. If they found that, then what?
If they found any concerns, they were obliged to forward that information to the NAS.
What says that they have to, any concerns they have to be reported to NIH?
Yes.
What says that? I didn't see that.
The Whitehead's brief actually amply sets this out, and I will look to see if I can find the pages for you. It is set out amply in the Whitehead brief and also the NIH policies. If you look at the footnote 2 of the brief, of our brief in chief, makes reference to that. Now, the NIH policies, it's also contained a little bit at the brief at footnote 1, Record Appendix 2, 130 to 131, 199 to 201, 203,
Your footnote 2 says that NIH funding recipients are required to investigate and take action, but it doesn't say anything about reporting the particular allegations or even the actions
I
to
think,
NIH? What?
and I'm happy to dig further in my notes, but there is a requirement of reporting. An institution is not free to tie something in a bow and stick it in a corner. That is exactly what Matt Lauer at the National Institutes of Health said will no longer happen with respect to sexual harassment
They
in particular.
can't, they got to take action. They've got to discipline the sexual harasser, hopefully fire that person, but what says they have to then report that to the NIH?
They have to report that they have done so. They have to report that there was a concern, and in this instance, they had to provide the independent investigation done by Hinckley Allen and Bill Sinnott.
Did they do that? Did they give the report to NIH?
They did. Yes, they did.
Do you know
And
where
so-
do you know where I'd find that? I didn't see that.
I think it is in the briefing, and we can find that for you. The issue of the scope of the petitioning activity, and I think the best way to deal with this is to look a little bit at what the law has found. Petitioning, both in the Superior Court and in my brother's brief, they would have you believe that it is only the direct filing with the government. The statutory language is to the contrary. It is anything that may reach the government, anything that may promote the discussion of an issue. Indeed, in ChemRisk.
Didn't Bristol Asphalt, I don't want to say pare it down, but limit that?
No, Your Honor. Actually, steadfastly no. Not with the scope of petitioning. Indeed, Bristol Asphalt acknowledged the breadth. And because the breadth is in the statutory language, Bristol Asphalt actually very clearly says, this is strong medicine. This is broadly written, and we are obliged to understand and appreciate its breadth. And it, in fact, cited with approval to Blanchard 1, where comments to the Globe that could maybe have reached the government were deemed petitioning. The Globe NAPS was also statements that are a mirror of what was said in a governmental filing are petitioning. And I suppose most notably, Burke versus Crunlin after Bristol was this court's decision. And in Burke versus Crunlin, you have a situation that is not on all fours with this, to be sure, but is close. You have a physician making a referral for another physician that they're worried about to PHS, the Physicians Health Services. PHS is not the government. It's recognized by the Board of Registration in Medicine as actually a sort of way around reporting a physician's conduct to the government. If an individual goes through PHS, and this addresses your concern a little bit, Justice Ditkoff, if a physician goes through PHS, some sort of remediation program, and they do it well, and they end PHS, and they go back on their way, there's never a government report. Burke found that the referral to PHS was nonetheless petitioning because it may have, although in that case it did not, result in any governmental report or referral. In this case, not only may her comments, her participation in the review, her urging others to participate in the review, may it have resulted in a report to the government, it did. And so in this case, more than in Burke, more than in Hanamura, this case constitutes petitioning, and petitioning is the sole basis of all of Dr. Sabatini's claims against Dr. KNOUSE. I am sure he will stand up here and say, well, she made a little comment here and she made a little comment there. But what is necessary here is it has to be a substantial basis apart from the petitioning conduct.
Let me just stop you for a minute in light of the time. I want to see if the panel, I think we're going to have to leave it there.
Okay. If I may just say, we will rest on the papers on 214-1C, and particularly I would ask the court to look carefully at the two amicus briefs that were filed. The Mueller brief very nicely sets out the reasoning why 214-1C should not have been dismissed in this case. And we also ask the court quite clearly, if we could, to honor the stay that we believe should have remained in place and that we believe Bristol makes very clear should remain in place until the resolution of this motion.
Thank you.
Thank you.
Mr. Foy, if I did my math right, and I'm not a math major, I believe that combined, we granted an additional 7 minutes and 59 seconds. Let's call it 8. So I will watch the clock. Let me just get the clock set for 15 minutes, please. And then if we go over...
The clerks were ahead of you. They set it for 23.
Well,
And now
I
we're back
know
to
Ms.
15.
Fisher's thinking ahead of me, but I have a method to my madness. So we're going to set it at 15 and see what happens. So when you're ready.
Fair enough. Good morning, Your Honors. My name is Edward Foy. I'm here for David Sabatini. I want to spend most of my time discussing the 12b6 dismissal, but I think just to wrap up the anti-SLAPP issue, the fact is, to answer Justice Ditkoff's question earlier, the report has never been sent to the NIH, at least not on anything that's in this record. You can find in Volume 2, page 260 of the record appendix, the first letter of Michael Lauer to of the Department of Health and Human Services to the Whitehead, which basically says, you know, we read in the newspaper about this Sabatini fellow being fired. What happened here? Shortly thereafter, on September 21st, Michael Barnes of Ropes and Gray, in a letter that's on Volume 2, page 263, writes back to the NIH and says to them in 4 single-spaced, well-reasoned pages, nothing to see here, move on. We took care of it. It's all been set. We followed our procedures. He's gone. You have nothing to worry about, and they did not include a copy of the report. And despite the fact that you have been given, by my count, about 1,000 pages of exhibits on the anti-SLAPP motion, that is everything you have from the Whitehead to the NIH and NIH to the Whitehead. And I believe, just for completeness, there's a paragraph or two in Mr. Mullins' affidavit, which I don't have right at hand, that mentions it. That is it. I do not see how one can reasonably say that it is petitioning the government to create a report when one then takes the report and puts it behind a radiator somewhere and doesn't even give it to the government. As to Bristol Asphalt, Justice D'Angelo's concern, I think that the key point of Bristol Asphalt is its policy statement that anti-SLAPP jurisprudence has gotten out of hand. It is, as Justice Kafka put it in that decision, strong medicine that is being overused. And the notion that it is now time to include it to every workplace investigation, and I don't see a principal distinction anywhere in the appellant's briefs, which would suggest to you that this workplace investigation, mandated by the government, is much different than any other workplace investigation which can be deemed to be mandated by the government. There's no specific NIH regulation to which you have been directed, nor I, which says that if complaint X is received, then you must go out and appoint lawyers and do what you do. Effectively, what this would be to do is to expand the anti-SLAPP statute to each and every, if not each and every workplace investigation, then any workplace investigation that can reasonably be argued to have derived from some government regulation somewhere. And I dare say there are very few businesses in the Commonwealth which could not say that some government regulation, if only the MCAD regulations themselves, required such an investigation.
You just asked my question for me, which is, if a private employer is required under MCAD to report sexual harassment, do you believe that that is petitioning?
I believe that report is petitioning activity. Yes, sir, I think that's very clear because it is a report to the government by the employer. That's the other key part of petitioning activity. It's not just a statement, it's a statement to the government or something's close enough to the government that we're willing to extend the petition. As in the Bohr case, the Department of Public Health, the board that works with the Board of Registration in Medicine to deal with physicians who have substance abuse issues, or Global NAPS, I think, not Global NAPS, but North American Expositions, a case that I briefed to this court about 15 years ago, which involved a South Boston quasi-governmental charitable institution which was created by statute. And this court effectively said, close enough. It isn't exactly the government, but it fulfills a governmental function insofar as it distributes funds for the benefit of the people of South Boston, and we're going to call this petitioning activity. It isn't when it is tangential or when it is someday create enough of a controversy that it will reach the government's attention. This is the other, I think, point about these cases that are being cited to you. When there is a governmental proceeding ongoing, occasionally people will say things about that proceeding outside the four corners of the proceeding, and this court will be forgiving about that and say, well, you're mirroring the statements in the proceedings. You're mirroring what's going on in the proceeding itself. Therefore, we will find this is under the anti-SLAPP. What happened here is this is entirely prior to, preparatory to, there is no investigation by NIH. There's nothing on the horizon. NIH learns about it, my goodness, from the Boston Globe. What sort of reporting is that? It simply does not fit in with the narrowed policy that, if it ever fit into the anti-SLAPP jurisprudence, the narrowing that Bristol Asphalt worked on the number of cases that should be considered for anti-SLAPP statute consideration, I think, puts an end to that argument. And by the way, I think you have had one other question Judge Ditkoff asked about whether the 12B6, about the fate of the
fees.
Pardon me, the fee petition.
Yes.
There is certainly case law that says that you do need to look at both the 12B6 and the anti-SLAPP, but I think in this case, Bristol Asphalt so completely eliminates the ground on which the fee petition rested that there is no point in it. I think even Ms. Hodge conceded in her brief, and if you listen very carefully in her oral argument, that the judge's decision to nick off a very small part of count 4 and to say that this part of count 4 violates the anti-SLAPP statute, Bristol Asphalt decisively and in terms reverses the case law that permitted her to do that. Under Bristol Asphalt, the entire count must now be dismissed. You cannot slice out a part. And I think that this was always a very small part of count 4. So given that it is so clear that the underlying basis for liability must be vacated, I think there is really no point in remanding for a consideration of the $493,000 fee petition that the plaintiffs filed. On to defamation and 12B6, if I may. The court below basically said that that the reason it was going to dismiss the defamation claims was because, based on Dr. Sabatini's complaint alone, it could find that, first, a conditional privilege for workplace investigations applied, and secondly, that Dr. Sabatini had failed to plead sufficient facts to show that the workplace investigation privilege had not been lost through abuse. There are 5 ways the conditional privilege can be abused. One can act out of malice, one can know that the information was false, one had no reason to believe that it was true, one can act in reckless disregard of another person's rights, or one can publish the information unnecessarily, unreasonably, or excessively. As far as I know, there's only one case in the Commonwealth which has invoked the workplace conditional privilege at the pleading stage to dismiss a claim. And that is a case called Sullivan v. Shirley, Commissioner of Corrections, written by one Justice Ditkoff. It was a singular case. First of all, the issue of whether or not it is appropriate to cast upon the plaintiff the burden of pleading his way around an affirmative defense that hasn't yet been asserted was not raised to him in that case, probably because the person who had his complaint dismissed was a prisoner and probably was not involved with the niceties of pleading. But I think it's well established under the rules of civil procedure, and we cite many cases about Rule 9C and others.
Well, in my defense, I don't remember whether that was raised in that case, but I certainly, in unpublished opinions, have dismissed based on privileges like that if they're established by the complaint.
Yes, and I think...
Agreed, if the complaint actually establishes the privilege, then that's a ground for 12b-6.
I think that's correct, Your Honor. And I think that in the case of the Sullivan case, the facts were so clear that there was no room for further development on discovery. What had happened there, for the benefit of your colleagues, as I recall it, was that a convicted murderer at Shirley was dismissed from the law library and his job as a librarian because he was told by the correctional supervisor of the library, things have gone missing from the library. And this court decided in that case that it was libelous. All of the conditions for libel had been met, but it was only said to the prisoner in response to his question, why did you dismiss me? It was said to him face to face. There were perhaps 1 or 2 other people who heard it, and that was the end of it. That was the full extent of the defamation. We are not talking about someone, in this case, we had an email sent to 247 individuals who promptly reported to the Boston Globe that David Sabatini was a sexual harasser. This is not quite the same case as Sullivan, and I think when it comes time for the court to ask whether David Sabatini must prove at the pleading stage that this conditional privilege has been abused, is to look to see whether he has alleged sufficient facts that could plausibly, once developed in discovery, lead to the conclusion that there has been an abuse of the privilege. And I'm going to just talk briefly, if I can, about 2 of them. The first is excessive dissemination, unreasonable, unnecessary, or excessive dissemination of the information. The conditional workplace privilege is intended to, and in almost all of the cases does, apply where one person in an organization is speaking to another person in an organization to discuss the plaintiff's job performance. That's why the privilege exists. It sometimes is invoked when an individual in one organization speaks to someone in a different organization, also usually with hiring or firing responsibilities, about the plaintiff, because these have common interest in whether or not the plaintiff is capable of doing their work. What did the plaintiff do during that time? This is completely outside the rationale of the privilege. The rationale of the privilege is to permit individuals within an organization to talk about their workers, and if necessary, to speak to the individuals in cognate organizations about those workers, and to do so in a frank and open manner and without fearing that they will be sued for defamation if they say things have gone missing from the library while this person was working there.
So why doesn't that apply to colleagues at MIT and Whitehead and to journals that are currently considering articles?
It might apply to MIT because Dr. Sabatini had a job at MIT, so sending a copy of the report to MIT might well have fallen within the privilege. But they did not send a copy of the report just to MIT. Justice Krupp, in a decision which was decided before Justice Kazanjian entered her order of dismissal, found that there had been excessive dissemination and that any privilege which had attached to it had been lost by excessive dissemination because in addition to MIT, it was also sent internally within the Whitehead to members of the board of directors with no further restrictions whatsoever on its dissemination. In other words, Whitehead not only handed it to MIT, to these other organizations, it did not restrict their ability to disseminate it. It gave a copy to KRISTIN and her lawyer. She had a copy before David Sabatini did. This, I think, is excessive dissemination by almost any standard. 246 people, an article in the Boston Globe. We know today from Discovery that the email that Dr. Lehman sent around was co-authored by their press agent, the individual who does their press, and it was intended for public consumption.
So I don't get that one. Someone makes a complaint of sexual harassment and you investigate it and then you want to tell the complainer what you're doing about it. Why wasn't that conditionally privileged?
I'm sorry, when you wanted to tell...
Why isn't it conditionally privileged to tell the sexual harassment complainant what you found and what you're doing about their complaint?
It is reasonable, Your Honor, but only if there are some restriction on further dissemination placed on it. It isn't to give it to someone and to then permit them to go out and disseminate it to whomever. There was no restriction placed on it. She was given a read-only copy, so in that sense there was a restriction. But that is as far as it went. And it's not just, again, I think it's not just the fact that MIT and the complainant are getting this. Eventually, it was circulated to a point where it appeared on Twitter. This is not holding, the rationale of the privilege is to simply keep it within the tight circle of individuals who need to know. When you send an email to 247 people knowing it's going to go to the Boston Globe, that is excessive dissemination.
What if you don't know it's going to go to the Boston Globe? Somebody who's being harassed knows there's going to be an investigation and sends it to all the employees and says, hey, I was harassed, there's going to be an investigation. If this happened to you, you should tell someone. Isn't that covered by the privilege because you want employees to disclose this during an investigation?
If she had done something like that, yes, it would have been. But that is not, I think, what we're really dealing with here. I think that this is not, for example, early in the process, there was a DEI survey which addressed these issues, and that seems perfectly reasonable that the results of that would be released within the organization. I think the problem happens, and again, the key to this, the key to the defamatory part is the sexual harassment and the independent investigation, because, and I need to address those, because the investigation wasn't independent. And the finding of sexual harassment rests on KRISTIN KNOUSE's testimony, and that testimony was false. We now know today that the investigation was not independent. There were emails exchanged between Dr. Lehman and Dr. Knouse, and phone calls, Dr. Lehman and Dr. Knouse, 3 months before the DEI survey and 4 months before the investigators were appointed. And in those conversations, they agreed, I will just read you from one of the emails. Dr. Knouse says to one of her friends, I told her how this improves the enterprise in two ways. Gets rid of one source of problems. It shows that no one is too successful to be taken down. Implied in 2 is that he must be taken down, and she was on board with these two parts being equally essential. Before the investigation has even begun, there is an agreement that he will be fired and that he needs to be fired based on KRISTIN Knouse's words alone. And that is what discovery has shown in the lower court, and you can consult that. Under case Jarraj v. Palmer, you are allowed to look at the docket of a related case pending in another court and the pleadings filed therein. And recently, in another case called Welter v. Whalen, an unpublished case, the court did just that in an anti-SLAPP case. So you can consult this information. So you can also see that Lehman had actual knowledge. Here's some of the other things the complaint pleads in connection with the allegedly independent investigation and whether it was preordained that Dr. Sabatini was going to be fired. You can read in the complaint that Dr. Lehman had actual knowledge that the investigators were using coercive interview techniques to push witnesses into making statements that fit with their predetermined conclusions. Under Lyons v. New Mass Media and similar cases, this is persuasive evidence of actual malice. One of the 3 factors, one of the 5 factors under the Downey case, which will avoid the conditional workplace investigation. The Whitehead relied heavily on Dr. Knouse throughout this investigation. Page after page of that report, if you inflict it on yourself, deals with her complaints about Dr. Sabatini, all of which were false and which she acknowledged to another MIT faculty member were false. She said, I've got to accuse him of acting as of having a toxic lab environment in order to get rid of him. She considered him to be a rapist, and she intended to get back at him by claiming that there was a toxic lab environment. That's at paragraph 7 of the complaint. A lot of the information in the report was derived from the anonymous DEI survey. The investigators didn't even know who they were quoting when they quoted the people from the DEI survey. Under King v. Globe newspaper, reliance on an anonymous source is persuasive evidence of actual malice. And under, again, the case I cited you a moment ago, Lyons v. New Mass Media, well, I think really the key case here is St. Amant v. Thompson, that reliance on a source one knows to be biased is necessarily evidence of actual malice. Actual malice looks to whether or not the individual in question, here Dr. Lehman, had good reason to doubt, or whether she entertained in fact significant doubts about the veracity of what was in that report. She knew for a fact that it didn't derive from the DEI investigation.
Your time is running low. Very low. And I just want to ask you, is the discovery issue properly before us?
It is, Your Honor. I think that there is, on 2 grounds, by the way. First, in the 12b6 context, the court needs to ask itself, are there sufficient facts here to justify discovery? You need to make all reasonable intendments in favor of the plaintiff. You need to not just read the complaint literally, but also say, is there enough here that we can infer that something else might have taken place? You can not only infer that something else might have taken place, it actually did take place. We've got the emails now. We had some emails that suggested they had been in contact and suggested to us, and we pleaded it in the complaint, that there was an agreement. We now have actual emails that show an agreement in KRISTIN Knouse's own hands. She's writing to her friends, telling her about how much on board they are, that Dr. Lehman is, with getting rid of David Sabatini.
Let me just check with the panel, counsel, because you are now over time, and I think you've answered Justice Ditkoff's question, so we're going to have to leave it at that. I will not hear rebuttal, This hearing is concluded. Thank you all. It is under advisement. We have one more case left in the courtroom. Thank you.
Thank you, Your Honors.
You can consult the rules for post-argument letters. Our last case is JH versus NF, docket number 23P709. As counsel sets up, I just remind you that it's partially impounded, meaning we're not going to use any names. And just counsel is at table, correct?
Yes, Your Honor. This is my colleague, David Ruskell.
That's your client?
This is my colleague.
Okay,
yeah.
that's what, I thought I heard something, and I was like, no, okay, want to make sure. Thank you, welcome, counsel. Let's just make sure, looks like everybody is out. I'm sorry, we've had a crazy timing, so I'm sorry that we're running a little bit late, but you have our full attention, counsel, when you're ready.
Absolutely. Good afternoon, Your Honors, and may it please the court. My name is Thomas Miller. My colleague, David Ruskell, is at the table here, and we represent the defendant appellant in this matter, NF. This is an appeal of a harassment prevention order that was invalid as a matter of law from the moment it issued. The original order was illegal because, as the plaintiff appellee concedes, it was not based on 3 separate acts. The evidence was thus insufficient under any provision of the statute, as has been repeatedly reiterated by this court and by our Supreme Judicial Court.
Counsel, is the original harassment prevention order actually before us on appeal?
Your Honor, so the first thing I would say is there's no dispute that the current order is properly before you. Our client appeared at the hearing, filed a timely notice of appeal, so that is certainly here for review by this court. We are asking for the original order to be reviewed as well. Under the circumstances here, we think this court can and should reach that. And the reason for that is really just the egregious nature of the original violation when the order was issued. So I would direct the court's attention to our record appendix at page 35, where the first judge who looked at this says, I don't think this meets the standard, and I don't have time to consider this, so I'm going to issue the order. The second hearing is sort of the most brief and cursory of the hearings that were held on this. This is just radically not it's radically not the way this is supposed to work. And we think that you now have the whole record before you, and you can see that that legal infirmity of not having those 3 acts the judge was completely correct to have that doubt. And we have pointed to the language in your decision, Justice Blake, in Idris I, about just the really unique nature of these proceedings where there are such significant consequences for defendants and serious due process concerns. We think this is really a case where those due process concerns were outside of the bounds, and that this court should go back and look at that initial order.
Do you have any case that says we can do that?
We would just point to Idris I in that case, because we do think that Justice Blake highlighted a unique issue that arises with these orders where there are significant consequences and very thin process protecting the defendant's rights. But again, the current order is indisputably before you and can be reviewed. So I think it's fairly straightforward about the 3-act requirement, but I do just want to emphasize that the evidence there was clear, that there was one encounter, one conversation in which some things were said. Exactly what was said.
But also, over the past 2 years, I have received a number of harassing and abusive emails from him. Why can't a judge take that as showing there were additional acts?
Justice Ditkoff, because what needs to happen here for them to be acts of harassment is they can't just be abusive or harassing in the colloquial sense, as the decisions say. They actually have to meet the standard in the statute. And the judge actually asked the plaintiff in this case very specific questions at the first hearing about the content of the emails. The emails themselves were, never offered to the court, and they're not in the record. But going off of the plaintiff's testimony, he said there were no threats of violence to him, no threats to damage his property, one of them contained an apology. They were, we don't have the emails in the record again, but based on what he said, they just don't meet even the statutory standard, let alone the constitutional standard that's in the background here under the First Amendment, because they were protected speech on the basis of what the plaintiff said.
Counsel, as to going to the subsequent hearings, your client didn't object to the fact that he didn't get to question the plaintiff or that he didn't say anything. So why aren't those issues waived?
So, Your Honor, I take it your question is focusing on sort of the due process issues at the last hearing?
I have a follow-up about your due process in a moment, but...
So obviously, our client was representing himself. It was pro se. It was clear that he didn't acquiesce to the way the proceedings were going, and he objected to how the hearing was being held. He didn't voice all those objections in the most appropriate way. He did highlight some of the due process issues, including the fact that he was on Zoom while the plaintiff got to be there in person. Our client offered to come to the hearing in person, and the plaintiff said that he couldn't accommodate that, and the court went ahead with that. So I think there were some...
No issue, at least in the record, that your client couldn't hear the proceedings, couldn't see the proceedings, correct?
Well, Your Honor, I think actually the first thing our client said was that he was having trouble hearing and that he felt like he was at a disadvantage. So I think he did put that on the record before the judge, that he was disadvantaged by the hybrid format of the hearing, if you will, and so that issue, I believe, is clearly preserved.
And how about your client's behavior at the end of the hearing? How does that affect or towards the end, how does that affect your due process claim?
Well, Your Honor, clearly our client was very frustrated at that point. He did not realize that these issues had been waived. He had not obviously gotten the affidavit. He had not been aware at the beginning of this about the factual allegations that had been made against him. Some of them were highly personal, that he was mentally unstable, suicidal. These were false. They were extremely inappropriate things for a mental health professional to say in court about our client. So clearly there was a very personal element there for him. And he was trying to get his side of the story in front of the court. And I think when it was clear from the judge that he was not allowed to present that, there was obviously visible frustration. It was not any sort of aggression that was directed at the plaintiff. And I think that's actually crucial because the determination that's being made at that hearing is whether the extension is reasonably necessary to protect the plaintiff. And there wasn't any evidence about that. And I think if you look at the transcript, it's clear that the judge was justifiably upset and imposed this very long and draconian 10-year extension as a result of that. And it's understandable that the judge was upset at the behavior in the courtroom, but that's not the right reason to impose that kind of extension of a harassment prevention order.
If we find the evidence was sufficient, do you find that the 10 years is an abuse of discretion?
Yes, Your Honor. I think that's clearly outside of the range of reasonable alternatives in this case, especially given that 3 years had elapsed and there had been no incidents or problems within those 3 years. So the 10-year extension was an abuse of discretion under these circumstances. So I do want to speak a little bit about some of the evidence. The three acts obviously not met. The Supreme Judicial Court and this court have analyzed that issue in a number of different ways in a number of different cases. I take it that my brother essentially concedes as much in his brief that the three acts were not there and attempts to rely on this other portion of the statute that functionally imposes the same three-act requirement via the case law on the stalking and criminal harassment statutes. I want to talk briefly about the evidence about suicide, threat of suicide and firearms. The reason why the statute has the three acts requirement is so that these orders are not issued on the basis of vague generalizations and sort of statements that someone is a bad or dangerous person. And that was exactly what happened in this case, that the plaintiff came and essentially said the defendant is a dangerous, volatile veteran, he has firearms, he's mentally ill, he's suicidal. There wasn't any evidence about these things. In fact, the record contained considerable contradictory evidence suggesting that these things weren't true. This is, with respect to the suicide, again, it's incredibly inappropriate for a mental health professional seeing a potential client to react to that by seeking a harassment prevention order, and I think does suggest that this was not done in good faith. With respect to threats of suicide in general, the case law that even considers that evidence really presents distinguishable circumstances. Looking at Constance C. and ASR, these are abuse prevention order cases where there's a huge volume of communications, and in that context of other aggression, these threats can be considered, but here they weren't even relevant under the law. They were just inappropriate. As far as firearms, the allegation was repeatedly that the defendant had access to firearms. This is so vague as to be completely unsubstantive. This is a country with the Second Amendment. All of us potentially have access to firearms in some way, shape, or form. And a harassment prevention order with its significant consequences should just not be issued on the basis of these very nonspecific suggestions. When it came out, when the evidence was eventually explored a little bit at the fourth hearing, it essentially amounted to the fact that our client had been in the military at some point distantly in the past. So the fact that our client did serve our country in the military should not become kind of a free-floating background color that allows plaintiffs to obtain restraining orders against him. I also want to briefly touch on the First Amendment issues, because I think that's, to whatever extent the plaintiff is going to rely on the emails.
Don't those have to be raised too?
I'm sorry, I didn't hear that.
Don't you have to raise a First Amendment issue in the district court?
Your Honor, I would say that the First Amendment issue, it's such an important issue of law that what Justice Blake said in Interest I, that this court can reach issues of law that were passed on below. I think the First Amendment, which is recently, the Supreme Court has recently said that, reiterated that true threats are a very narrow category where they're important.
Why would we think that the judge below decided the First Amendment issue when it wasn't raised?
Your Honor, I would say that the issue of the emails being protected speech is such a salient and important constitutional right that it was incumbent on the judge to look at that issue and consider it. But I think the reason why it wasn't explicitly reached by the judge is that the emails so clearly didn't meet the statutory standard. The judge asked, were there threats of violence, were there threats of damage to property, and no. So the constitutional issues sort of weren't reached because it seemed like the statutory threshold had not been met. But I think that if this court is looking at the record as a whole, it should consider the constitutional protections for speech that are relevant to those emails, in addition to the statutory. And so that the constitutional analysis is, and the Supreme Judicial Court has read this analysis into the statute in O'Brien, that they really have to be true threats. They have to be, credible threats of violence against the plaintiff, or fighting words. It can't be that it was merely harassing, intimidating, or abusive in the colloquial sense. Based on what the plaintiff said about the emails, they don't even reach, the colloquial sense, I would say. But we do think that they are protected speech and can't be the basis for a harassment prevention order under any theory in the statute. I see I'm just a few minutes, so I want to briefly just talk about the extension hearing and the standard that the judge didn't properly apply there. The first and sort of fundamental thing that the judge needs to assure themselves of for an extension is that the plaintiff is a person suffering from harassment and thus sort of eligible for the protection of 258E in a fundamental sense. In this case, the plaintiff was not and never was a person who was suffering from harassment because of the lack of 3 acts that constitute harassment in the definition in the statute. So that's the first thing, and the judge is supposed to look back and consider the basis for the original order, look at the totality of circumstances in light of the original order. That should have been the moment where the judge looked at what the 3 incidents were, looked at what the basis for that original issuance was, and seen that there was not a basis, no harassment in the meaning of the statute. And then a second reason why the extension was not justified is that the burden is on the plaintiff at that hearing to show that an extension of the order is reasonably necessary for continued protection from harassment. And there needs to be essentially a new finding at that hearing that the continuation of the order is necessary. There was no evidence that the plaintiff presented at that point to meet that burden. There had been obviously no contact in the intervening period. It's not required, but I think that's evidence that there was not a continuing need. The judge sort of commented, essentially, this is just a reiteration of the old allegations. Your affidavit is just saying the same things. To the extent that the judge at that hearing sort of relied on, again, vague statements about mental instability or firearms, we've explained why we think that would be clear error in terms of relying on those as...
Can I ask you about the firearms, because it may go to the length of it? According to the affidavit, which the judge read to your client on Zoom, when the police went there, they recovered an illegal assault rifle and hunting rifle with a scope. So why isn't that enough evidence for the judge to believe that he had access to firearms and he might still have access to firearms?
A number of reasons, Your Honor. So first of all, our plaintiff, our client, denies that happened, that he had any access to those firearms. He said on the record of that hearing that he didn't go to this place. So even if, assuming, arguendo, that these firearms existed somewhere, there wasn't evidence that he had access to them or used them or had ever been seen with them. Also, the plaintiff's claims about these firearms got kind of gradually amplified over the course of these different hearings, and I would submit that allegation is not credible on its face. When police find illegal, improperly stored firearms, that doesn't sort of pass unnoticed. Those are, crimes to have firearms in that status. And so the fact that this was made sort of en passant suggests that this was not a good faith allegation.
We're going to have to leave it there, counsel. Thank you.
Thank you, Your Honors.
Attorney Puleo.
Thank you, and good afternoon to this honorable court. I appreciate the questions of the panel thus far. As I said in my brief, I don't believe that the basis of the original order is before the court. Clearly, the hearing judge at the most recent extension pointed out to the appellant, your chance for challenging that has gone, and the appellant even conceded. Granted, he's not an attorney, but he conceded at that time, yeah, I know that, Judge, but I still want to talk about stuff. So as I indicated in my brief, I think the only issues that are properly before the court are the conduct of that last extension hearing. In terms of the legitimacy of the issuance, I think I agree that with my brother that both stalking and criminal harassment require a pattern of conduct, 3 or more. The difference, though, I think, the way I understand the statutes in the case law, is that under section 1 of harassment under 58E, 258E, you need 3 threats. And I apologize for a footnote inviting this court to maybe revisit the SJC law on that. That is my position. I hope someday somebody gets a chance to do that. But under both criminal harassment and stalking, you need a pattern of conduct that's not threatening. So to Justice Ditkoff's point, the emails are what we're relying on. A series of emails over a pattern of years that annoyed and alarmed my client. And that's enough under those criminal statutes. This court knows that there doesn't need to be any conviction. It's just conduct that would violate those statutes, that I respectfully submit that it would. And so there was a basis for the original order.
Let's talk about the extension.
Yes.
How do we get a 10-year extension? Your client didn't even ask for 10 years, did he?
He was asking for a permanent extension and actually asked for the permanent extension the previous hearing, and the judge at that hearing said, well, it is during COVID. We're trying not to do that unless we have the respondent, the defendant present. So we're going to, give him yet another opportunity to appear, even though he had an opportunity to appear at every one of the hearings, but for obviously the initial ex parte hearing. I think the law allows for permanent hearings to be placed, so that I would say in response to your question, 10 years is appropriate.
Why is it appropriate under this evidence?
Well, because what my client had repeatedly said to the serial judges that had considered the matter, what concerns me is the emotional volatility of this person. And he's described the incident where the actual threats were made and clustered all together, was what it sounded like, okay, he came to my office, we're going to have a meeting, and quickly escalated into threats and menacing posture and statements of violence. I'm going to kill you, I'm going to blow you up. And so my client had been focused on that and reported that to each of the serial judges. And then when it happened, I'm sure the court remembers in the transcript of that final hearing, when my client said to the judge, that's the volatility that I've been talking about, and the court said, yes, I see it. So I think that's ample evidence and a basis for the judge to conclude this person is unstable enough, and he didn't allow my client's request for a permanent order. He limited that to a 10-year order.
Can I ask about the due process claim that opposing counsel makes? At some point in the hearing, while the judge is talking on Zoom, he explains to the defendant that you're going to have an opportunity to ask questions, and then I'll hear from you or argument. Where in the record does he give the defendant the opportunity to question the plaintiff?
It's not there because the defendant appellant left.
Well, before he leaves, he speaks at length to the court, and this is on, 68 through 70-something in the record. So there's a conversation going on between him and the judge.
Yes.
So before that conversation, the judge never turns to him and says, would you like to ask the plaintiff any questions?
I think respectfully, if my memory is accurate, Justice, of the record, the judge said, I'm going to let you hear from you now. After having said a couple times, here's how it's going to work, Mr. Appellant, I'm going to ask some questions, and I'll allow you to ask some questions or argue to me as well. The order shouldn't extend. At the beginning, he said that twice, and then when he turned to the appellant then started to make all the speech.
And the judge says, I'll hear from you.
Yes.
So you think that's the invitation for the appellant to say, oh, I want to ask her some questions? Normally in the proceedings, the plaintiff testifies.
Yes.
Judge turns to the defendant or his lawyer and says, do you have any questions for the plaintiff? In this case, it was, I think, as you just said, I'll hear you now, or something to that effect. So that was the opportunity to ask the questions?
I confess I don't recall the specific statement that the court made that, I appreciate the Justice's question. If you don't mind, I'll try to locate it.
I think on page 62, that's where the judge sort of says, do you have any questions? And then the defendant launches into his big...
Yes.
So he waived his opportunity to ask questions, is what you're arguing.
My argument is yes. Thank you. It is page 62. As the judge is explaining, he does say, do you have any questions for my client? And then the appellant goes into that exchange, and then it goes awry based on the volatility I respectfully suggest of the appellant. So, again, I think I agree with my brothers that whether it's harassment as defined in Section 1 or harassment because acts that violated section of criminal harassment or stalking, 3 acts are required. I think the emails plus the threats to prove the stalking, the emails alone would be criminal harassment. And so I do think that this court ought to affirm the extension of the order, and I don't know that I have any other points to make.
Let me check with the panel. I don't see any other questions for you, so we're happy to take the rest of the argument on the brief.
Do you mind if I just review my notes briefly?
Not at all.
Thank you, since I have a few minutes left. Just for clarity, my client is not a mental health professional. My brother said a couple times he's the executive director of the program, but he's not a clinician, my client. I think that's in the record that he's the director of that program, but he's not a mental health professional. The access to firearms, if it's all important to the court, the police, according to my client's testimony to the lower court, the police did recover firearms. It's not, oh, theoretically there were some guns. There were 2 rifles recovered from the appellant's mother's home. And at the time of the original issuance, that was the address that everyone had for the appellant. And the last thing, if it's important to the court, I commented briefly in my brief that a lot of my brother's argument accepts all the appellant's factual representations, even about, well, the clerk told me this was going to be on Zoom, when clearly the clerk spoke on the record and said, this is an in-person hearing. So respectfully, I know this court ought not to be engaging in factual determinations, but I submit respectfully that certainly every district court judge that heard from my client made a ruling and found his report and testimony credible. And so I think that further reflects a lack of abuse of discretion. And I didn't cite the case for the standard of review, but I did cite the case, but not for that proposition. But I know that this court knows that the review is for an abuse of discretion, which I respectfully submit is not present.
Thank you very much. The case is under advisement. It's very nice to have 2 lawyers on a case like this. We often don't see that, so it was very well briefed and argued, and we appreciate that. Thank you. That concludes today's list, and we will stand in recess. I'd like to thank the court officers, the law clerks, and the timekeeper. Have a good afternoon, everyone.
If we're off the record?
We are.
I quipped to my brother that after the previous case before us, you saved the best for last.
I agree.
Pretty entertaining argument before us. Thank you.